Appeal dismissed.
Deeply. Item 3, FAO 31 of 2023.
Appeal dismissed.
Item 4,
Just a
CRPIO.
Just a clarification, Manoj. This matter was actually never argued by us. If you remember.
Yes.
well.
Which matter?
Item number 3, Lordship.
Okay. They will check the record.
Yes, okay. Let me check the record.
Item 4, CRPIO 57 of 2024.
Petition allowed.
5, bail application 2475 of 2024.
Petition dismissed.
CRPIO 14 of 2024.
Petition allowed.
May I please, Lordship? I beg to mention item number 37, Milord. This actually, Milord, we both the sides had agreed, Milord, on the last occasion, and Lordship was pleased to, Milord, order that this matter be disposed of, Milord, the final hearing, Milord. But it's come for orders, Milord, and it was in fact fixed for tomorrow, Milord, 24. But today has come for orders, Milord. Item number 37.
Oh, hearing.
Well, yes, Milord, because Lordship, last occasion, prayer was made by Mr. M.K. Chaudhary, Senior Counsel, Milord, and it was agreed later on, Milord, that this matter will be disposed of, Milord, that LCS have also come, Milord.
Tomorrow we will take it up then.
Tomorrow, Milord.
Yes. As agreed by learned advocates of both sides, races will list the matter tomorrow.
Milord.
May I please, Your Lordship?
Yes.
No, I beg to mention item number 13.
1-3.
Well, there are some mistakes in filing in the revision petition. For the annexers are concerned. We'll correct the annexers before the register. And it may be listed on Friday
Next Friday.
next.
Okay.
After correcting the annexers.
On the prayer being made by Mr. S.C. Sharma, learned senior counsel, assisted by SC shall list the matter on Friday.
After correcting the
After making necessary correction in the
revision petition.
revision petition.
On 27th,
On
Friday, 27th.
May it please your lordship. My lord, I pray for listing this matter in the next hearing list, my lord. Matter is urgent, relates to tenancy case, my lord.
When?
Next hearing list,
When do you want?
my lord.
When do you want?
On expiration of this present list, my lord, next list will come, hearing list. So in that hearing list, we will have the question.
Okay.
Make please, your lordship. My lord, I beg to mention item number 32, lordship. I need 4 weeks time to implement the new incumbents, lordship.
Item number
32, lordship.
32. Mr. K. A. Majumdar, learned counsel for the petitioner. Press for listing the matter on
After 4 weeks, lordship,
after 4 weeks.
to enable me to implement the new
So as
incumbents.
to enable him to implement the new incumbents.
Lordship.
Prayer allowed.
And lordship, I beg to mention one item for RSA, lordship, for admission, lordship.
When?
Subject to convenience, this week.
After vacation, Lordship, after vacation.
Is there any urgency?
This is their lordship, last occasion, lordship, supposed to admit, lordship, we filed, honorable court was asked to file additional affidavit regarding some documents. We filed it, lordship, additional documents with affidavit, lordship. So if
Okay, on
convenient,
first or second? Okay. Second is holiday.
1/4.
I beg to mention for listing of a CRP lordship, and I have filed it on 17/9. There was some defect which was clarified lordship,
When do you
and
want?
tomorrow lordship, next date is on 25th lordship in the trial court.
Tomorrow.
Tomorrow being hearing day, so many cases already matters.
Otherwise, lordship, next date is fixed on 24th.
We'll try tomorrow.
Oblige, lordship.
May it please your lordship, I pray for listing a CRP lordship
Yes,
in this week lordship, anyway.
CRP.
Yes, lordship,
Is there any urgency?
yes, lordship. Proceedings of the trial court has been already listed lordship, and this honorable court was direct to list after 2 weeks. But till date, this matter was not listed lordship. This week, any date lordship. For admission. Okay.
27.
Oblige lordship.
May it please your lordship,
Yes.
I beg to mention for MSC April for listing for orders
When?
after vacation. Oblige.
May I please your lordship, my lord, I beg to mention for listing of one RFA, my lord.
When?
RFA on Wednesday, my lord,
When?
25th, my lord.
Lordship, after vacation, lordship.
If there is
There's
no
some
urgency, then after
There
vacation.
is some urgency, my lord, because my lord, the respondent as plaintiff filed a suit for specific performance, my lord. The learned trial court passed a decree in favor of the plaintiff, my lord. Agreed by this, the defendant has filed this first appeal, my lord, and the order of the learned trial court has been stayed.
Okay,
this week-
On 1st of October, we'll try.
1st of October, my lord.
Before lordship, that before lordship for listing a matter which was last listed 28/2/2024.
Hmm.
Compassionate appointment, my lord.
Hmm.
It may be listed on any day in this week, my lord.
How is it possible?
Last list on 28/2/2024.
In which column you want to be listed?
My lord, column, orders column.
Orders
On
column.
30.
May I please watch it? I beg to mention item number 22, the matter may kindly be adjourned for the day and fix it in next week.
You are appearing on behalf of?
BJ Mukherjee.
Your good name, please?
A Shah.
Ms. A. Saha, learned counsel appearing on behalf of Mr. B. Mukherjee, learned counsel for the appellant. This is a list the matter on. When?
Also date to be fixed by the registry in the next.
Much better. Your Lordship, I beg to mention MEC appeal for listing for tomorrow, Your Lordship.
In which column?
Order, Your Lordship.
Tomorrow. Okay.
Oblige.
Yes.
Just paying for listing of one CRP lordship which was filed on 17th of September on a day after tomorrow lordship 25th. The matter is being fixed on 30th lordship. Before that some interim prayer is there. So I'm just paying for listing on.
On Friday, we'll try.
27.
27.
Friday.
Also, the difficulty is that the stay order is granted, then again I have to obtain the certified copy. So 28, 29 is Saturday and Sunday. So the 30th Monday is the date next date fixed lordship. Can be taken on Wednesday lordship. Just filed on 17th of
Wednesday,
September.
we have lot of matters. Not possible.
And Thursday lordship.
Not possible.
Thursday lordship is
Your matter may not raise. Thursday is a hearing day.
then
27 September.
Public.
Attempt for withdrawal, item number 7.
May it please your lordship. Lordship, I have instruction to withdraw this petition, lordship.
You are for?
For the petitioner,
Your good name?
D Roy on behalf of TS Hazari.
Do you have Ukalat number here?
Lordship,
You have file Ukalat number here?
lordship, I'm for the respondent, lordship.
You put a respondent.
TS Hazari, on behalf of TS Hazari. Petition,
T.S. Hazarika is petitioner.
lordship. For the petition, lordship, on behalf of TS.
Your name?
D Roy, lordship.
In the Ukalat, not in the cause list.
My name is not in the cause, lordship. I'm on behalf of TS Hazari.
Yeah, Mr. Sulso, learned counsel appearing on behalf of Mr. T.S. Hazarika, learned counsel for the petitioner. Submits that he has the instruction to withdraw this petition. There is allowed, this transfer petition is disposed of on withdrawal.
Obliged. Motion, item number 8.
May it please your lordship. My lord, this revision IO has been preferred against the order passed by the learned Munsif of North Lakhimpur in a title suit, my lord. My lord, the opposite party instituted a title suit in the court of the learned Munsif
order dated 6/6/2024 passed by the learned civil judge, junior division cum JMHC Soreto in title execution case number 4 of 2023 is challenged in this petition under Article 227 of the Constitution of India, read section 151 of the Code of Civil Procedure. It is to be noted here that by impugn order dated 6/6/2024, the learned civil judge junior division Soredo has dismissed the petition number 206 of 2024 filed by the petitioner for staying execution of the case. Mr. Shayola, learned counsel for the petitioner, submits that the petitioner was a respondent in the title suit.
No, I am the plaintiff, my lord.
Acha.
I was the plaintiff, I declared some right to interest on adverse person, and they filed a counter claim for a person.
The petitioner as plaintiff has instituted a title suit, being title suit number 5 of 2011 for declaration of right, title, interest, and permanent injunction on the basis of adverse position. And the said suit was dismissed and decreed in favor of the respondent. On account of default of the present petitioner.
Not a suit, my lord. Appeal. If you filed an appeal was dismissed. That is at page 40.
No, against the judgment and decree in title suit.
Yes. Title appeal 4 of 21.
Wherein the learned trial court has dismissed and decreed the suit in favor of the respondents. Thereafter, the petitioner has preferred an appeal before the learned appellate court. So, learned appellate court being appeal number, what is the number?
My lord, page 42, title appeal number 4 of 21.
Title appeal number 4 of
4 of
2021.
21. 4 of 21.
2021.
Civil judge.
But the same was dismissed
For default.
for default. Dismissed for default. And thereafter, the petitioner had preferred one petition for restoration of the said
Appeal.
restoration of the said appeal on when you have filed the petition.
Well, the death is not, well, immediately we have filed, my lord, because the council approached, my lord, to file them. Immediately they have filed, my lord. Because the council, my lord, reached lately after from Sibsagar, my lord.
Immediately file the appeal. Now file for restoration of the title appeal, upon which Ms. J case number 02 of 2024 was registered. And the same is, while the same is pending before the court, execution proceeding was started before the learned trial court. Being title execution case number 4 of 2024, wherein the petitioner had filed a petition for staying the said petition. No, staying the execution proceeding. But by the impugn order dated 6/6/2024, the learned executing court has dismissed the petition on the ground that the said court has no power at that stage under the CPC for staying the execution. Mr. Sayola, learned counsel for the petitioner referring to rule 20 order 21 submits that since the restoration petition is pending before the learned appellate court, the executing court may stay the execution proceeding till disposal of the said appeal. And I said restoration petition. Pero Having heard the submission of Mr. Sahayullah, learned counsel for the petitioner, and also when I have carefully gone through the petition and the documents placed on record, and also filed the interim order dated 6/6/2024, and also the relevant provision that is ordered 21 Rule 26 of the Code of Civil Procedure. Further, taking note of the submission of learned counsel for the petitioner, and also considering the relevant provision of law and the event facts and circumstances on the record, this court is inclined to allow this petition. It is provided that the learned trial court, learned executing court shall stay the execution proceeding, being title execution proceeding number 4 of 2023, till disposal of the Ms.J. case
Case number 2 of 24.
by the learned first appellate court. In terms of above this, CRPI or this stands disposed of at this most on this itself.
Then 44,
It's a matter, my lord, where the plaintiff filed a certified copy of the cell deed. We objected to the same that he has not filed an application under 663, and that is secondary evidence that cannot be. Now, the learned trial court held that this is a public document, and certified copy is admissible at page 68, my lord. Equally, my lord, this is a case. He said that it is a public document as per section 74 of the Evidence Act. New theory has been. Page 69, it has been held by. The document, as aforesaid, comes in the purview of definition of the public document as per section 74 of the Evidence Act. Velocity for this, page 69. Further, section 77 of the Act provides that contents of any public document or any part thereof may be proved by production of their certified copies, and under section 79, court can presume such document to be genuine. Thus, the law is very clear pertaining to public documents, and contents may be proved by production of certified copies for which no permission is required to be taken for this from this honorable court as stated in the so. So far, cell deed is concerned, my lord, it is always a private document, my lord. Always a private document. Now, if your lordship want, my lord, I can place a judgment of the Supreme Court, larger bench, my lord. It is 21/4 SCC 786.
Have you placed that judgment before the trial court?
No, only, my lord, it is, what are the public documents? It is given there, my lord. Private documents which are kept by the state, only that is the public document. It is a registered copy, my lord. Certified copy of the cell deed is only. Paragraph 22, my lord, may be seen, my lord. All along, my lord. With the established law, my lord, they everywhere, my lord.
Paragraph number 22.
Yes, paragraph 22, my lord. In fact, so a certified copy, my lord, the earlier judgment has been referred to, being the ship signed by the owner was held not to be a public record of a private document under section 74(2) of the Evidence Act, for the reason that the original has to be returned to the party under section 61(2) of the Registration Act. This judgment has been followed in so and so by the division bench Madhya Pradesh High Court, in which it was held so and so. Which I approved, my lord. Thus, my lord, the last sentence written. Thus, the factum of registration of what is otherwise a private document, inter-party, does not plot the document with a higher legal status by virtue of his registration. The last. I'm placing another 2004 7 SCC. Always, my lord, it doesn't help, my lord. There is a take the objection is to be taken at the initial stage. Section 65. Here also certificate of the selling.
Which paragraph you have relied upon here?
Well, 13 and 14, my lord, in the second case. That initial stage you have to raise objection, my lord. Was not find merit in this, in the present case, objection was not that certified copy so and so is inadmissible, but mode of proof was rejected by insufficient. Objection to mode of proof falls within the procedural law. Therefore, objection could have been raised, second so and so so and so. Now that has been said, my lord, that initial stage, my lord, there are 14, that they have to take objection, my lord. Here also, it is certified copy of the salary. There are 12 which your lordship see, my lord. And Mr. Carol Suri, learned counsel submitted that once the document becomes incapable of being proved for want of primary evidence, the foundation of secondary evidence must be laid, without which secondary evidence was inadmissible. In the present case, no steps were taken by the plaintiff to produce the original salary. That no steps were taken. This is submitted that foundation is laid under section 65. If the plaintiff is able to prove the original salary was lost, then the secondary evidence was admissible. But in absence of such foundation, High Court erred in holding that registered certified copy of the salary was admissible in evidence as documents produced modern certificate. So here, my lord, the same thing, my lord, that objection is to be taken at the initial stage, my lord. Because this is not a public document, my lord. This is a private document. Private document only registered with the, my lord, the original is returned. So there cannot be any much problem.
Yeah, we'll go through the judgment, we'll pass the order.
Item for admission, item number 17 and 18.
Very good. Okay. This is regarding the release of pensionary benefit, pension and pensionary benefit to the petitioner. He is retired on 39/2018. The respondent authority has refused to give the pension and pensionary benefit on the ground that there is a disciplinary proceeding pending. Disciplinary as well as criminal proceeding is pending against the petitioner, but there is no departmental proceeding was initiated in 2008, lordship. Thereafter, the petitioner filed an application before the authority to inspect documents. But thereafter they did not give any opportunity to the petitioner to spectra documents. In the meantime, Lordship, the petitioner was suspended in the year 2006 in connection in a medical fraudulent withdrawal of medical bills, Lordship. He has been implicated in this case. Subsequently, he was in police custody for 48 hours. For that, he was suspended on 29/11/2006. Subsequently, the honorable court, this honorable court granted bail on 18/12/2006, Lordship. But and High Order dated 1/3/2008, he was reinstated in his service as junior assistant in under the Director of Elementary Education, Lordship. On 4/7/2008, Lordship, a show cause notice under Rule 9 of Assam Service Discipline April 1964, read with Section 311 of the Constitution of India was served upon him, stating giving the allegation that he has along with some other person has withdraw some medical imbalance bill of the some of the employees under the Director of Elementary Education. Against that so-called notice, he has filed an application under on 11/7/2008 for inspection of the documents. I have annexed all this with the copy of so-called notice and lecture 1, 2, and my his letter dated 11/7/2008 of the petition for inspection of the annexure 3, Lordship. In the year of Lordship 2013, the Director of Elementary Education also published a gradation list where his name was placed at serial number 3 of the junior as a junior assistant. But his junior was promoted. Therefore, the petitioner has
Madam,
also
what is your pair in this petition?
for release of the pensionary benefit.
Pensionary benefits. So, why you were submitting on his promotion then?
Yes, because it is related, Lordship, I have annexed an annexure 6, the order of the honorable, of this honorable passed in WPC number 1693/2015. That order really, page 51, relevant portion of the order, Lordship. May I read, Lordship, paragraph 14 of this?
Paragraph 14 of?
Page 51 of the earlier order of this honorable court, Lordship.
Yes.
May I read it? Regarding pendency of the departmental proceeding, it is seen that the show cause notice was issued to the petitioner way back on 4/7/2008. Petitioner has stated that he could not submit his written statement in reply because he could not peruse the relevant documents to enable him to submit his written statement, as those were not furnished to him. If it is admitted by the director in this affidavit that no documents relating to these charges framed against the petitioner are available in his office, as they are in the custody of the CID. Consequently, the petitioner could not go through the relevant documents, and as a result, he could not submit written statement. This is the position after 8 years of the issuance of the so-called notice. The disciplinary authority has also not taken the stand of that because of the failure of the petitioner to submit the written statement. The charge framed against him stood proof. No order to that effect has been passed. A departmental proceeding cannot continue against a government servant for an intermediate period. Consequently, the promotion cannot be denied on the ground of the pendency of such departmental proceeding.
Admittedly, junior assistant who were placed before the petitioner in the gradation list have been promoted to the petition, the post of senior assistant, superseding him. In the factors and circumstances, the court is of the opinion, view that the relevant reason given for non-consideration of the case of the petitioner for promotion are not tenable. Accordingly, and in this light of the above, the Director Elementary Agents, Assam is directed to consider his promotion of the petitioner from junior assistant to senior assistant in the directive with effect from the date of when respondent number 4 was promoted to the post of senior assistant with all consequential service benefit except salary. Let the above exercise be carried out within period. Thereafter, he has been promoted as a senior assistant, and on 30/9/2018 he was retired. He has retired from the service lordship. Till today, they have not released a pension and other benefit.
Yes, madam.
And in this case, we have filed our affidavit, my lord. In page number 55, my lord. I have stated that, my lord, in that case, my lord, the petitioner has been suscited, my lord, and the CID case is under trial, my lord. That's why, my
Lordship, there is no case pending
No,
against.
let it pass.
Yes, Lordship, yes,
Yes,
sorry.
my lord, page number 56, my lord.
yes.
First parameter, it may be stated hearing that the petitioner so-and-so LDA, the director of answering deponent was suspended on so-and-so date in connection with the CID PS case number 6 of 2006 by the office of the answering deponent by order dated so-and-so. And the department proceeding was done. He was reinstated in his original post of place of posting with immediate effect by order of answering deponent by memo number so-and-so dated 1/3/2028 without prejudice to the departmental proceeding. It is pertinent to mention herein that the petitioner, Umesh Kumar, has in the meantime superannuated from his service on 30/9/2018. It may be further be stated herein that as reported by the Superintendent of Office CID, Assam Ulubari, Guwahati White communication dated 17/6/2023, the petitioner has been solicited in CID case number so-and-so under section so-and-so, and the case is under trial, my lord. Hence, the completion of departmental proceeding against the petitioner, Umesh Kumar, does not arise vice the regulation of the suspension period of the petitioner cannot be considered, my lord. Perhaps, my lord, the petitioner is receiving provisional pension.
But can you deny his regular pension on this ground? Can you deny his regular pension?
But since the case is under trial, my lord.
Is there any rule for holding up his regular pension because of pendency of this criminal proceeding?
By filing the affidavit in reply, I have mentioned about that no departmental proceeding as well as lordship criminal proceeding is pending against the petitioner lordship. And the petitioner never received any summons from any court regarding that. They have not mentioned previously also this honorable court as they were directed them to show where is the case pending, but they failed to show the case before the honorable court. Now they have come again, same plea, they have taken the same plea in this case also, regarding pension and pensionary benefit.
Mother, page number 59, with is the so-called notice.
That is so-called notice in 2008 lordship.
In page 61, my lord.
And
then status, my lord, where petitioner name is shown as CL number 14, my lord.
it is not, there is no mention
from the, my lord, Additional Director General of Police, CID, Assam, Ulubari, Guwahati. Page 61.
At what stage the proceeding is pending, criminal proceeding?
No, lordship. I have never received any, I never appeared before.
I am asking her, not you.
Lordship.
Please sit down. Yes, madam.
Present state
Now,
of mind.
at what stage the criminal case is pending?
And at that stage, but I need to take instruction, my lord.
In 2018, we
Then in which court it is pending? Obtain instruction, then you
I did.
appraise this court. Third is MDiv, learned counsel for the and this Every learned counsel for the
No, Panchali is very good. Panchali at
You have for the respondent number, madam,
Lord,
1, 2, and 3.
one, my lord, apni pay for 6 secretary madam. And I am paying for 2 and 3, madam. One, my lord.
Okay, and madam,
ED Burma, additional.
former learned counsel for the respondent number 1. None appears for the respondent number 4. Having heard the submission of learned counsel for both the parties, it is provided that recusal is the matter immediately after reopening of the petition, so as to enable Ms. Delhi to obtain necessary instruction in respect of the present status of the case, being CIDPS case number so and so. And appraise this court on next step.
And that may be fixed lordship in this case. So he is in the deathbed lordship, he is in a hospitalized, seriously ill. It is pending since 2018,
30 October.
This petition is.
2020.
30 October.
After reopen, after 24, it is better lordship. I will be out of state for 4 days.
30 is the restate.
Same or 18 is tag matter, madam? 18 is tag
Same
matter.
law regarding disciplinary, I have not filed any affidavit in this case also.
19.
Meet please, my lord. My lord, this revision petition was filed for a direction to the executing court to expeditiously dispose of the execution. Now, my lord, why this was filed is because an arbitral award was passed in favor of the petitioner in the year 1999. Thereafter, a money execution application was also preferred before the district judge Golaghat in the year 2009. But since then, till today, 2024, no satisfactory execution has been recorded in that particular case. Time and again, applications have been filed. Erstwhile, in this case, the father of the petitioner had preferred it. However, later on, after his demise, when he came into the helm of affairs, he also preferred applications for disposal of the expeditious disposal of the execution application. The only limited prayer, my lord, is if a direction is given that the same is expeditiously disposed of. Otherwise, a liquidator has also been appointed in respect of the respondent society. And the liquidator's report is also before this honorable court, wherein he admits regarding the liabilities which are due to the petitioner. That is a flag M.
So council, this court will not take up this matter as at some point of time, this court has dealt with this matter before the learned.
Very well, my lord, may fix it before any other.
This before any other.
20.
Your lordship, kindly the matter may be passed over for the
For the day,
time being, lordship.
time being.
21.
But in this case, whether the predecessors of the respondent is the brother of the present appellant. Along with their mother, they had a partnership business, and to that effect, a valid partnership agreement was there. Subsequently, the mother died, and partnership continued with both the brothers, that is the predecessors of the respondent and the appellant. Subsequently, the brother died, that is the predecessor of the respondent.
So by the implication of the section 42 of the Partnership Act, the partnership stood dissolved. Now, the legal heirs of the said brother, deceased brother, that is the present respondent, filed a commercial suit, claiming among others for declaration that they are entitled to the one half share of the partnership assets and liabilities. Your lordship will find the prayer. Plaint is at page 13, my lord. And the prayer your lordship will find page 23. Declaration that the partnership firm of Messrs. Verma Market had already.
Yes.
Page 23, last. Declaration that the partnership firm of Messrs. Verma Market had already been dissolved on the date of Sampatlal Verma, or alternatively a decree of dissolution of partnership firm of Messrs. Verma Market. Declaration that the plaintiff are entitled to half share of surplus and sale proceeds of the assets and properties of the firm, if any, after meeting the liabilities of the firm, etc. Now, my lord, we have filed an application under section 8, my lord, pointing out that the agreement on which they have relied on regarding the partnership, it contains a arbitration clause. So under section 8, the judicial authority or the court are restrained from exercising the jurisdiction. It has to refer to the arbitration. That objection petition I have filed at page 38.
You first show me the deed
Deed melody is at page 29.
and the relevant column.
Page 37.
Yes.
So wide enough to include all the dispute that may arise between the parties. Now I have filed the this application, page 38. I have pointed out and also quoted the particular clause of arbitration and paid for referral of the dispute to the arbitration. Now the court has passed an order on 9/8/2024, which is at page 47. The relevant portion will be from page 55. Court has admit that there exists a valid arbitration agreement. It has also
Page number 50.
it will operative part the relevant will be page 55 onwards. Paragraph, the third paragraph. Upon perusal of the judgment furnished by both the sides, all that which becomes apparently clear before the court is that application of arbitration is undeniably attracted in a situation when there exists an arbitration clause between the parties to the contract, and the same is beyond any iota of doubt. Moreover, the ratio laid down by the judgment furnished before the court also makes it clear that in view of section 40 of Arbitration and Conciliation Act 1996, the date of a party to a contract does not discharge the arbitration agreement between the parties. However, there is a diversion to the aforesaid phenomena, and the same is that all the judgments referred by the petitioner side undeniably refers to the incident related to existence of an arbitration clause either between the individual person or else between a partnership firm having more than two partners, as well as the scenario in case of death of one of the partners of such firm having more than two partners as parties to the dispute. Incidentally, the present situation in hand is slightly different, as because although perusal of the facts narrated by the parties reflects about the existence of a firm having three partners in its inception, yet it is apparently clear from the argument stated by both the sides during the course of hearing that after the formation of the partnership deed, two of the partners, that is Lalmati Devi Verma and thereafter said Sampatlal Verma, had expired one after another over the course of time, thereby leaving behind said Rampatlal Verma as the sole surviving partner to the partnership deed. That being the position, the partnership firm had automatically come to an end, and that too immediately upon the death of said Sampatlal Verma, as because the question of partnership does not survive, owing to the contractual nature of the said partnership firm. As such, I find strength to lean in favor of the ratio laid down by the Honorable Apex Court in the case of SP Mishra and others versus Liaquddin Khan reported in 2019 10 SCC 329, wherein the Honorable Apex Court has discussed that a partnership firm stands there dissolved statutorily by operation of law owing to the death of partner in a partnership firm having two partners, and as such, the death of one of the partners statutorily dissolved the partnership firm in itself owing to the operation of law. Moreover, I do not find strength to lean in favor of the submission made by the learned counsel for the petitioner, reflecting the non-applicability of the judgment passed by the Honorable Guwahati High Court in the case of Dara and Company versus Commissioner of Income Tax, that is reported in 1993 200 ITR 467, merely because the same pertains to a dispute related to income tax, as because although the aforesaid judgment pertains to discussion on certain issues related to income tax, yet a meticulous perusal of the said judgment further reflects that the Honorable Guwahati High Court in the process of deciding the said income tax issue had also thoroughly discussed the fact that if one of the two partners of a firm dies, then the firm automatically comes to an end, and thereafter no partnership for a third party is to be introduced therein, and as such there lies no scope for application of clause C of section 42 to such a situation. Insofar as the question of arbitrable nature of the subject matter of the disputed is concerned, I am of the considered opinion that discussion on the point of applicability of arbitration clause to a partnership firm having the sole surviving partner being left behind in such a firm is sufficient enough to decide the petition filed by the petitioner, defendant number 1 under section 8 of the Arbitration Act, Conciliation Act, without going deep inside other aspects which were raised by the parties in the instant miscase during the course of hearing. So thereby, my lord, dismiss the said application. Perhaps Lordship may like to
Topic after 5 minutes.
Application clause has not been disputed by the either side, and it is also admitted by the court. And the only ground is that, my lord, the judgment those have been referred are either relates to existence of a partnership between two individual or different firm, and not with regard to the consequence of a death of a partner. That is one of the ground. And secondly, it is said, though the dispute is arbitrable, but the intricate question that has arisen as, my lord, appearing from the application under section 8, it is only the civil court, it can, my lord, decide the, my lord, issues, my lord. While passing that judgment, before that, my lord, the court has relied on the two decisions, that is of 2019 and the, my lord, Guwahati High, the judgment of this court. Both the cases does not, my lord, relates to any, my lord, arbitral, my lord, clause. So far as, my lord, and in the case of, my lord, SP Mishra 2019 10 SCC, that appearing in, my lord, page 56. There the issue was, my lord, the decree was passed against the, my lord, defendant. Then, my lord, execution case was filed. During the course of the, my lord, execution, the defendant died. Now they have brought in the legal heirs for the purpose of execution of the decree. In that context, my lord, relying on the section 42C, it says with the death of the parties, the partnership firm stood automatically
42C of
42C of the Partnership Act.
yes.
So therefore, automatically since these legal heirs were not a party, so automatically the execution cannot be proceeded against the legal heirs of the deceased judgment debtor. So that is the case. There absolutely, and that is the proposition of law. That is the specifically mentioned in section 42C of the Partnership Act. With the death of the person is to dissolve. Now, this aspect, my lord, has been, my lord, only taken by the learned trial court, and to constitute that as because the the partner, the surviving partners has died, so the partnership should dissolve. That is the implication of it is fine. But then the question is whether by dissolution of the partnership that the commercial agreement automatically dissolves the denuded the arbitration clause. The court has failed to notice section 7. Firstly, section 7 specifically says, if I am permitted to read
Arbitration Act.
of the Arbitration of Conciliation Act.
Yes.
Arbitration agreement, in this part, arbitration agreement means an agreement by the parties to submit an arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. 2. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement, which clearly provides that commercial contract and the arbitration contract, it's a totally two different agreement. It may contain in the form of a clause in the commercial contract itself, and or it may have a separate agreement to that effect. And this interpretation has been given by this apex court also, in the case of AR 22. Whether food, oil, fuel, noodles. AR 2022, Supreme Court 5229. Please. 5229.
Yes. Relevant paragraph.
Lordship. Here, Lordship will come to relevant paragraph, paragraph 9. Married. The doctrine of separability and the doctrine of competence encompassed in the arbitration jurisprudence have been scientifically explained by a 3 judges bench of this court in recent case of NN Global Merchant P Limited, Supra. It is well stated, subtle in arbitration jurisprudence that an arbitration agreement is a distinct and separate agreement which is independent from the substantive commercial contract in which it is embedded. This is based on the premises that when parties enter into a commercial contract containing an arbitration clause, they are entering into two separate agreements. That is the substantive contract, which contains the right and obligation of the parties arising from the commercial transaction, and 2, the arbitration agreement, which contains the binding obligation of the parties to resolve their dispute through the mode of arbitration. The autonomy of the arbitration agreement is based on the twin concept of separability and competence. The doctrines of separability and competence through interrelated are distinct and play an important role in promoting the autonomy of the arbitral process. The doctrine of separability of the arbitration agreement connotes that invalidity, ineffectiveness, or termination the substantive commercial contract would not affect the validity of the arbitration agreement, except if the arbitration agreement itself is directly impeached on the ground that the arbitration agreement is void ab initio. Now here the court, in our case, court categorically finding existence of a valid arbitration clause. Then you also may of the same judgment paragraph 23 as well, madam.
Yes.
Page 23, paragraph 23. The point for consideration is whether the non-payment of stamp duty on the work order would render the arbitration clause invalid, non-existent, or unenforceable in law till the stamp duty is paid on the substantive commercial contract. Well, in this case, the commercial contract was not stamped, but it contained an agreement arbitration clause. So the question was, as because by the Maharashtra Act, since the stamp is not paid with regard to the commercial contract, it is not effective under the law. In that case also, whether arbitration clause will survive. So that was the question mark that has been raised, my lord. Not 24, my lord. The arbitration agreement contained in the work order is independent and distinct from the underlying commercial contract. The arbitration agreement is an agreement which provides the mode of dispute resolution. Section 3 of Maharashtra Stamp Act does not subject an arbitration agreement to payment of stamp duty, unlike various other agreements enlisted in the schedule of the Act. This is for the obvious reason that an arbitration agreement is an agreement to resolve dispute arising out of a commercial agreement, though through the mode of arbitration. On the basis of the doctrine of separability, the arbitration agreement being a separate and distinct agreement from the underlying commercial contract would survive independent of the substantive contract. The arbitration agreement would not be rendered invalid, unenforceable, or non-existent, even if the substantive contract is not admissible in evidence or cannot be acted upon on account of non-payment of stamp duty. In our view, there is no legal impediment to the enforceability of the arbitration agreement pending payment of stamp duty on the substantive contract. The adjudicating of the right and obligation under the work order or the substantive commercial contract would, however, not proceed before complying with the same. So the main contract cannot be proceeded, but so far as arbitration agreement is concerned, it will proceed, my lord. It still survives. That is the, my lord, that has been laid, my lord.
Even
And-
after death of one of the partner.
Yes, my lord. So far as the terms of the commercial contract, that may not be enforceable against the legal heirs because it's to dissolve. But so far as the dispute arising out of the said partnership agreement will be subject to the arbitration clause or the arbitration agreement. And this position has come up very clearly after the amendment of 2015, but that has not been taken into consideration by the court. There's a distinction between the prior to 2015 amendment and 2015. The 2015 amendment, it made any person claiming true. That is another aspect which at this stage I'll not press upon. The second, after this 2015 amendment, the position is now clear. The moment the court sees that there is an arbitration agreement, it will refer to the arbitration. It is for the very fact of section 5. That this section 5 has also, section 5 and section 16, these two provisions have also been has gone unnoticed of the honorable learned trial court. The section 5 speaks of a starts with a non-obstructive clause. Section 5, extent of judicial intervention, notwithstanding anything contained in any other law.
Yes.
Extent of judicial intervention, notwithstanding anything contained in any other law for time being in force in matter governed by this part, no judicial authority shall intervene except where so provided in this part. Now, the moment the court sees that there is an agreement, it has to refer to the arbitration. And for any reason, even if the court for any reason it sees that the particular suit here, the declaratory suit can be tried by him, then also he cannot, because of the application of application under section 8, because under the Arbitration Act, the court is the principal civil court of the district. That is the district judge. So therefore, all the arbitration matters are dealt by the district judge or the delegated power by the additional district judge. But here the senior the civil judge has exercised his jurisdiction. It is absolutely without jurisdiction. It is entirely the to that effect. The judgments are also there. I'll put it. This is to, my lord, moment he sees, my lord, that the arbitration agreement is there, my lord, it has to refer, my lord. And on that context, my lord, I'll say, my
No,
lord,
this regarding this jurisdiction.
lordship.
So how the matter is that assistant senior civil judge?
My lord, he has filed a, my lord, commercial suit for declaration of certain right based on the partnership agreement. Till then, it is all right. But the moment I have submitted the application under section A, the court is noticed that there is existence of a, my lord,
Arbitration clause.
arbitration clause. So it is denuded of its power to decide section 8 petition as well, my lord. There is no option but to refer to the,
District judge.
my lord, to the arbitration, my lord.
No.
Or to return the plain to place it before the appropriate court, my lord. That is up to the, my lord, the court, my lord.
No,
But
whether the civil judge can refer it to the refer it to arbitration. Whether he has vested with that power.
yes, my lord, because it is the judicial authority, he is not exercising on merit. Moment it is seen, that's what, my lord, what I am submitting on the recent judgment of the 2024 by the apex court. It is clearly said, my lord, moment you notice the, my lord, existence of a, my lord, arbitration agreement or the clause, you have no option but to refer it to the, my lord, arbitration. Unless, my lord, the arbitration clause or the arbitration agreement is itself shown to be, my lord, void ab initio. So that is, my lord, 2024. There are several, my lord, paragraphs which deals on the issue, my lord, involved in the present case, my lord.
Paragraph number.
Lordship, my lord. My lord, paragraph well, the question that was posed is at paragraph 2. The only question to be declared by us here is whether the trial court and the high court have rightly referred the matter to arbitration, or the dispute is of such a nature that it is not liable to be referred to arbitration, as there was no arbitration clause in the conveyance deed dated 17/12/2019, or if there was yet the matter in any case as such that is not arbitrable. One of the facts in that case was, my lord, the partnership agreement which was, my lord, executed, it did not contain the arbitration clause. But subsequently, two tripartite agreement was entered by this partnership, where the arbitration, my lord, clause were existence. Then also court says, yes, since the entire dispute can be sorted out through this arbitration clause, so it is covered by the arbitration clause. Accordingly, my lord, affirm the judgment of the, my lord, courts below for referral. My lord, did find, my lord, the paragraph 7. The role of a court is now in a case extremely limited in arbitration matters. The underlying principle of arbitration as contained in the Arbitration and Conciliation Act 1996 was always to have a little interference as possible by a judicial authority. Then, my lord, section 5 has been, my lord, quoted, my lord. Section 5 of the Arbitration Act as under, my lord. This has been quoted, my lord. Then lordship may skip this paragraph, and my lord, come to, my lord, paragraph 17 directly, my lord. There's several, my lord, paragraphs contains it, my lord. Paragraph 17. After the 2015 amendment, primarily the court has also got it. Paragraph 17. After the 2015 amendment, primarily the court only has to see whether a valid arbitration agreement exists. Additionally, the clear non-arbitrability of case, such as where a party to the agreement is statutorily protected, such as a consumer, has also to be seen by the court. Bus alias supra, my lord. I'll take your lordship to this bus alias supra also. Sort of the narrow field stated above, the scope of judicial scrutiny at the stage of section 11(6) of section 8 is extremely limited. So, my lord, after the amendment, only to see, my lord, whether a valid arbitration agreement exists.
Hmm.
And the, my lord, what has been given in, my lord, Booz, my lord, that is referred in, my lord, paragraph 10. Page 4, my lord. Paragraph 10. This court has set apart cases where the dispute was totally non-arbitrable, such as matrimonial disputes, guardianship disputes, or even we may add disputes relating to consumers which are governed by an entirely different parliamentary legislation known as Consumer Protection Act. So, my lord, these are the, my lord, cases what has been given, my lord. Then the this, my lord, the amendment also has come, and, my lord, the present position, what has been, my lord, stated in paragraph 17. And then paragraph 13, your lordship, these are also the, my lord, subsequent judgment, which has also, my lord, supporting the plea I have raised before this court, my lord. Then in paragraph 19, paragraph 19, that the second is the another objection, that is second is that the suit filed by the appellant is for cancellation of a document relating to immovable property, that is land, and if therefore amount to an action in rem, and hence arbitration is not the remedy. This question, however, is no more res integrata. Elaborate analysis on this aspect has been done by this court in the case of Deccan Paper Mills so-and-so. Therein, this court, after referring to all the relevant precedents and the case laws, has held that whether it is a suit for cancellation of a decree or a declaration of right rising from the deed, it would only be an action in personam and not in rem. The decision of the division bench of so-and-so has been traced. So, my lord, the arbitration dispute can be, my lord, resorted to only in, my lord, dispute in, my lord, personam. If it is in rem, then it is, my lord, comes to the, my lord, the jurisdiction of the civil court. But here it is not a case whether it is cancellation, declaration, it is in, my lord, not in rem. And so far as, my lord, the jurisdiction of, my lord, the civil court will have no power and jurisdiction, that, my lord, 2017 of our High Court, my lord.
My lord, I believe I have a right to know what
Yes.
decision my land
Yes,
is
yes,
citing.
Definitely.
My lord, we must know, we must enrich ourselves. Now, the idea is that he will secretly tell your lordship.
No,
only
I'm
that we do not know.
No,
My lord, see of the judgment he has placed, I do not know what judgment it is. Because I can help your lordships after reading that also.
Yes, yes.
This idea is not good, my lord. Because earlier what happened, my lord, whenever we cite a decision, we tell the other side also. So that the other side, you cannot take by surprise. This is not only to your lordship, they should inform us also. That is what I am not finding. And your lordship will find, without, my lord, spoiling so much of time, if your lordship look at the Arbitration Act, there is no Arbitration Act, we are not signatory to that agreement, then how can you argue all these things? My lord, I will take your lordship to that. It's a matter of 5 minutes.
Okay. Mr. Soikia, you furnished copy of the judgments to him well in advance.
Yes.
so
My
that-
lord,
No, I am not asking for copy. At least he should inform what judgment he is citing.
No, I have given you. My lord, inadvertently, my lord, I could not give. Otherwise,
Okay.
the first one I have already mentioned to him, my lord, because.
Okay, furnish a copy to him now.
But
If available, we will.
concentrating on the
Nowadays, my lord,
submission.
I think registry will, my lord, pass an order that whenever it is Delhi, it is there. But here we haven't adopted that yet. But then time has come, whenever we cite a decision, we should give it to the other side also.
Yes, yes.
This for all, my lord. For the betterment of, my
No,
lord.
this is already there in the Guwahati High Court rules that.
But we haven't adopted yet.
So that has to be adopted. My lord. Today, my lord, I was concentrating on submission, so therefore all the citations, like only 3 cases I have cited, 2022 Supreme Court 5229, I think I have given to him. Then secondly, I had referred to 2024. AR 2024 Supreme Court 197. 2024 Supreme Court 197. Sushma Sivkumar Daga versus Another and Madhur Kumar Ramkrishna ji. The third one, my lord, I had referred 2017. Guwahati, Air 2017 Guwahati 190. Limlas Rotary Trading.
পাহৰি যাব পাৰে নামটো
Citation to ভুল হৈ গ'লে দিগদাৰ হ'ব। Malad, this 2017 Guwahati, malad, 190, malad. Malad, facts are, malad, at paragraph 3 and 4, malad. The petitioner's case is that the petitioner was the sole distributor of online and paper lotteries in the state of Mizoram on the basis of two agreements dated 1/7/2008 for online lotteries and 26/5/2009 executed by the petitioner and the state of Mizoram. The petitioner's counsel submit that the respondent filed money suit number 47/2011 before the court of the senior civil judge Aizal, alleging that the petitioner failed to comply with the provisions of the above agreement and prayed for a decree for payment of rupees 2,39,794 with interest. The trial court thereafter passed ex parte judgment and order and decree dated 24/6/2011 in money suit number 47 of 2011 by decreeing that the petitioner was to pay the respondent the sum of rupees 2,39,794 with interest at the rate of 12% per annum with effect from 15/4/2011. That is the date of institution of the suit till final payment, cost of so and so. Now, my lord, this judgment was challenged, my lord. So it may come to paragraph 6, my lord. It was an ex parte decree. You will find civil judge has passed an ex parte decree, my lord. That was challenged before the High Court, my lord. Paragraph 6, the petitioner's counsel submitted as per the terms of the two agreement made between the parties are to refer any difference of dispute arising out of the agreement to arbitration. Accordingly, the respondents should have referred the matter to arbitration and not gone to a civil court in violation of the terms and conditions of the agreement. Now, the findings of the court. Paragraph 10. A reading of clause 18 of the agreement dated 26/5/2009 shows that the same is subject to clause 17 of the agreement, which requires party to go for arbitration in case of any dispute or differences arising out of the agreement in question. Then, my lord, will find paragraph 3, section 2E and 5 of the Arbitration Act has been mentioned. Then paragraph 14. A reading of the above two section would go to show that the court of the civil judge does not have any role to play in matters regarding arbitration. A perusal of section 5 of the Arbitration Act would also go to show that the court ought to have referred the respondent case for arbitration as the two agreements executed by the parties have not annexed along with the plaintiff in money suit number 47 of 2011. In the present case, no notice was received by that is on the other ground. In the present case, no notice was received by the petitioner and neither has the trial court made any observation or finding of the notice have been deemed to be served upon the petitioner. Keeping the above view, the trial court should be directed to respondent to go for arbitration proceeding as per terms of and condition of the agreement intention above. A perusal of the order sheet also goes to show that notice was issued to the petitioner only on so and so. Thereafter, on 18/5/2011, the matter was again fixed on 24/6/2011. On 24/6/2011, the order sheet as follows: since the defendant neither appears nor filed WS till the without knowing reason, judgment and decree is framed and is pronounced in the open court. Besides the above, a perusal of the original record, money suit number 47, shows that besides the two agreement dated so and so, which were submitted along with the plain before the court, no other document was submitted by the respondent while making their claim for recovery of rupees so and so. Further, no evidence that is on the other side. So therefore, here what it says, the senior judge did not have the jurisdiction because it is a matter of arbitration. That is, things, my lord. The tribal issues are there, my lord. Therefore, my lord, I pray that matter may be admitted. My lord. And my lord, during the pendency, my lord, the further proceeding in the suit may can be.
Yes.
My lord, I'll take your lordships to page 56, my lord. To take your lordship to the MP in order, then I will come to the legal position. Lord, incidentally, from there, my lord, I will read. Incidentally, the present situation in hand is slightly different as because although perusal of the facts narrated by the parties reflects about the existence of a firm having 3 partners in its inception, yet it is apparently clear from the argument stated by both the sides during the course of hearing that after the formation of the partnership deed, 2 of the partners, that is Lalmati Devi Bharma and thereafter said Shampatlal Bharma, had expired, one after another over the course of time, thereby leaving behind said Rampatlal Bharma as the sole surviving, this is important, my lord, as the sole surviving partner to the partnership deed. That being the proposition, the partnership firm had automatically come to an end, and that too immediately upon the death of the said Shampatlal Bharma, as because the question of partnership does not survive owing to the contractual nature, your lordship kindly mark that, contractual nature of the said partnership firm. As such, I find strength to lean in favor of the ratio laid down by so and so, reported in so and so, wherein in the Honorable Appeals Court has discussed that a partnership firm stands itself dissolved statutorily by operation of law, owing to the death of a partner in a partnership firm having 2 partners, and as such, the death of one of the partners statutorily dissolved the partnership firm in itself, owing to the operation of law. Moreover, I do not find strength to lean in favor of the submission made with the learned counsel. Well, that is also in regard to the same. Now I'll take your lordship to section 42C of the Partnership Act. Dissolution and the happening of certain contingencies, my lord, 42. We are concerned with C, the death of a partner. Now, the partnership was consisting of the 2 partners. On the death of one partner, it is automatically dissolved by operation of law. Therefore, the so-called partnership deed, as your lordship has seen, these they are relying on much on the, which starts at page, my lord, 30. Deed of partnership. It starts from page 29. They are relying on this. And in the partnership deed, there is an agreement at page 37. One clause is there. This clause 15. In case of any dispute or difference of opinion regarding the partnership affairs, or regarding dissolution or discontinuation of the partnership business, or at any time, the matter shall be referred to arbitration. Now, on the death of one partner, the partnership by operation of law is dissolved. So therefore, you cannot fall back to clause 15. It automatically goes. Then your lordship can see the Arbitration Act, section 7. That is arbitration agreement. The lordship got it.
Yes.
Arbitration, in this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. 3, an arbitration agreement shall be in writing, or an arbitration agreement is in writing if it is contained in a document signed by the parties. Now, this is very important. That agreement will have to be signed by the parties. Now, here, my lord, the respondents are not the signatories to that partnership deed. Therefore, my lord, he cannot say that we are parties, we are signatories to that arbitration clause.
So who are the signatories to the agreement or
These
deed
earlier,
of partnership?
earlier partners, my lord, your lordship will find it.
Hmm.
My lord, at page 37, my lord. Shampatlal Barma, then Rampatlal Barma, then Lalmati Barma. These Shampatlal and Rampatlal, they are two brothers, and Lalmati is their mother. Now, Shampatlal died, and the Lalmati Barma also expired. Now only remains Rampatlal Barma. So, my lord, when one person remains, the partnership by operation law, it will dissolve in terms of 42C. Now, the respondent said in they are not signatories to this arbitration clause. Then, my lord, your
They are
lordship,
the legal heirs of
legal heirs of
other
this-
partners.
Yes,
Who suffered demise.
this Shampatlal. Then your lordship turned to section 8 of the Arbitration Act. Power to refer parties to arbitration where there is an arbitration agreement. A judicial authority before which an action is brought in, a matter which is the subject of an arbitration agreement, shall, if a party to the arbitration agreement or any person claiming through or under him, so applies not later than the date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Then number 2, this is very important. Application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. Now, where is that arbitration agreement? My lord, when you file a petition under section A, you must annex, my lord, arbitration agreement, so that in order to scrutinize the prima facie case, whether it can be referred to or not. Now, these are, obviously it cannot be, because they are relying on the partnership deed, which the partnership firm has already been dissolved. There is a clause in clause 15. Now, by virtue of that, they want to bring it. Then, my lord, I will take your lordships to certain decision of the appeals court. My lord, first decision is 2019 10 SSC 329. 2019 10 SSC 329. And the next decision of this honorable court, 1993 1 GLR 155. This one. Naam to the Bishop Lord. My lord, your lordship first see the 2019 10 SCC. I will refer paragraph 12, 18, 21, and 22. The lordship may see paragraph 12 first. Paragraph 12 at page 333.
Yes.
On the other hand, it is contention of Sri so and so, learned senior counsel appearing for the respondents that as there were only 2 partners, and on death of one of the partners, partnership stands dissolved. In view of the provision under section 42C of the Partnership Act, it submitted that when the right litigated upon is readable, only in such event decree can be executed. It is submitted that the respondents were not the partners in the partnership deed, and if any clause in the partnership deed which runs contrary to statutory provisions are void, such clauses are against the public policy. It is submitted that when the partnership itself stands dissolved on death of one of the partners, the appellants claiming right under a decree obtained by the original partner cannot be executed against the respondents. That clinches the entire issue, my lord. Then your lordship kindly see paragraph 8. At this stage, it is to be noticed that once the partnership comes to an end, by virtue of death of one of the partners, there will not be any partnership existing in which legal representative of late so-and-so could be taken in. The judgment and decree obtained by late Sri so-and-so against late so-and-so in pursuance of partnership deed dated 14/4/1982 cannot bind the legal representatives of late so-and-so, as such decree is not executable against them. The legal representative of late so-and-so are not the partners of the original partnership deed dated 14/4/82, exactly in our case. When such legal representatives are not parties to the contract, such contracts cannot confer right or impose obligations arising under it on any third party except parties to it. No one but the parties to the contract can be entitled under it or bound by it. Such principle is known as privity of contract. When the partnership stands dissolved by operation of law under section 42C of the Partnership Act, the question of execution in pursuance of the decree does not arise. There cannot be any contract unilaterally without acceptance and agreement by the legal heirs of the deceased partner. If there are any clauses in the agreement entered into between the original partners and the third party, such clauses will not bind them. Such of the clauses in the partnership deed which runs contrary to the provision of Partnership Act are void and unenforceable. Such clauses are also opposed to public policy. Then, my lord, paragraph 21 and 22. From a reading the foresaid judgment, it is clear that the executable decree depends on the rights litigated by the parties. In the case on hand, the original decree was obtained against the predecessor of the respondents, who was party to partnership deed. In view of death of one of the partners, the partnership itself stands dissolved statutorily by operation of law in view of provision of section 42C of the Indian Partnership Act. When the respondents are not parties to the partnership firm, they are not bound by the decree obtained by the predecessor of the appellant. More so when it is a case of the respondents that they have not derived any assets and liabilities arising out of so-and-so. It is also to be noted that during the lifetime of late so-and-so, we also filed a suit number so-and-so on the file of Senior Judge City Civil Court, Hyderabad, for dissolution of partnership fund constituted under deed of partnership dated so-and-so, also for rendition of accounts. It is true that same is different partnership, but parties are same. In such suit filed by late so-and-so, predecessor of the appellants late Sri Jainara and Misra filed IA number so-and-so to dismiss the said suit, claiming that in view of death of one of the partners during the pendency of the suit, there is no room for third party to be introduced. It was the case of Jainara and Sharma that partnership stood dissolved. However, in a similar situation arising out of partnership deed dated so-and-so, the appellants claim the decree is executable against the respondents who are the legal heirs of the judgment debtor. As much as we are of the view that the respondents were not parties to the partnership deed and that the partnership stand dissolved in view of the death of one of the partners, the respondents have not derived the benefit of assets of the partnership fund. The decree obtained by the predecessor of the appellant is not executable against the respondent's hearing. Now, my lord, 1993 1 DLR, page 155. The lordship may look at paragraph 16. In CIT MP Shed Govindan Sugar Mills, the Supreme Court dealt with a case of partnership consisting of only two partners, and the deed contained a contract to continue. The partnership in the case of death of a partner by admitting legal representatives or nominees of the deceased partner. The income tax officer denied registration to the partnership on the ground that after the death of one of the partners, the partnership automatically dissolved, and thereafter the surviving partner and the heir of the deceased partner could not be treated only as association of persons. He treated the income as that of association of persons. His decision was confirmed by the superior authorities, including tribunal, but the High Court overruled the same. It was argued for the revenue that Section 42 of the Indian Partnership Act, which stipulated inter alia that subject to contract between the partners, a firm is dissolved with the death of a partner, applies only to a partnership having more than two persons. This was resisted by the SEC,
for whom it was argued that the heir would automatically be inducted in the partnership, and therefore it was not a case of dissolution. The SSC sought support of Section 30 of the Partnership Act. It was argued inter alia that subject to a contract between the partners and to the provision of Section 30, no person shall be introduced as a partner into a firm without the consent of all the existing partners. The Supreme Court observed the fundamental principle of partnership, therefore, is that the relation of partnership arises out of contract and not out of status. Section 42 can be interpreted without doing violence either to the language used or to the said basic principle. Section 42C of the Partnership Act can appropriately be applied to a partnership where there are more than two partners. If one of them dies, the firm is dissolved. But if there is a contract to the contrary, the surviving partners will continue the firm. On the other hand, this is in our case, my lord. On the other hand, if one of the two partners of a firm dies, the firm automatically comes to an end, and thereafter there is no partnership for a third party to be introduced therein. And therefore, there is no scope for applying clause C of Section 42 to such a situation. Maybe that pursuant to the wishes of the directions of the deceased partner, the surviving partner may enter into a new partnership with the heir of the deceased partner, but that would constitute a new partnership. In this light, Section 31 of the partnership falls in line of Section 42. The next decision, my lord, is 2008 2 SCC, page 602. My lord, it is relating to, my lord, if you rely on Section 8, you must place an arbitration agreement, which they have failed. In this context, your lordship may look at paragraph 16 and 19. My lord, I am sorry, my lord, on one copy. After reading, I'll hand it over to your lordship. I'll read slowly, my lord, and I'll hand it over. It is an admitted fact that neither Sri Rajendra Prasad Singh nor are the plaintiffs parties to the partnership deed dated so and so. There is no document as defined in Section 7 of 1996 Act, which may contain the signature of either Rajendra Prasad Singh or the plaintiffs. Similarly, there is no document as contemplated by clause P or C of subsection 4 of Section 7 of the 1996 Act, from which it may be spelled out that either Rajendra Prasad Singh or the plaintiffs were parties to clause relating to arbitration contained in the partnership deed dated so and so. It is also an admitted fact that Sri Rajendra Prasad Singh was alive when the said partnership deed dated so and so was executed. Therefore, the face of it, Section 8 of the 1996 Act would not apply to any dispute concerning the said partnership deed dated so and so. The matter cannot be referred to arbitration. Then paragraph 19. My lord, I think time is over at 2, my lord.
Continue.
Yes.
No, you continue.
Oh, all right. Then paragraph 19. There is no whisper in the petition dated 28/2/2005 that the original arbitration agreement or a duly certified copy thereof is being filed along with the application. Therefore, there was a clear non-compliance with subsection 2 of Section 8 of the Act, which is mandatory provision. The dispute could not have been referred to arbitration. Learned counsel for the respondent has submitted that a copy of the partnership deed was on the record of the case. However, in order to satisfy the requirement of subsection 2 of Section 8, would have filed the original arbitration agreement or a duly certified copy thereof, along with the petition filed by him on so and so. Now, in this case, my lord, they have miserably failed to furnish that arbitral agreement. You know, I have other some points, my lord. Your lordship may take it at 2.
How much time?
It will take at least half an hour.
Half an hour.
Half an hour, I'll try to cut short the time, but tentatively, my
No,
lord,
if you can finish it in 15 minutes,
my
then
lord,
okay.
I think it will take more than that.
More than that. Okay, then okay. No, order has already been passed.
Lordship, it was passed over for time being, maybe.
This one.
Item 2.
Okay, okay. On the pair being made by Ms. R. Sudhuri, learned counsel for the petitioner, this is the matter when.
Before vacation, if possible, or Lordship.
Let it be after vacation, otherwise.
After vacation, immediately after reopening the vacation.
Oblige.
Continue.
My lord, I will take your lordships to paragraph 44 of the appeal petition, my lord.
42.
44.
Yes.
In order to show that he has submitted to the jurisdiction of the, my lord, commercial suit.
Mm.
My lord, your lordship will find he has made a statement on 26/4/2024.
Mm.
He filed an application saying that the original deed of partnership should be given to him, despite the fact that that deed is with him, with a prayer that after that he will file a written statement. Now, in such a situation, what will be the legal position? I will highlight that. Now, your lordship, can you see the page 44, paragraph 11?
Hmm.
That with respect to the statement made in paragraph so and so of the said petition, the plaintiff submit that on 23/2/2024, the defendant number 1 received the summons of the instant suit with a copy of plain documents and list thereof, and thereafter on 26/4, this is the my lord application is filed.
Hmm.
On 26/4/2024, despite having the original of the partnership deed, filed one petition bearing number so and so dated 26/4/2024, asking for a direction to the plaintiff to furnish the original copy of the partnership deed and furnish the legible copy for which he could not prepare and file his written statement, and further paid time to file written statement. Now, this is I am highlighting because of the reason, once you file such an application, you have submitted yourself to the jurisdiction of that honorable court. Now, in that prospect, I will take your lordship to a decision. Now, before that, my lord, lordship may see page 20 also. Assuming that this can be referred, then whether the arbitrator can adjudicate this. Your lordship, can you see page 20? Page 20, column C, my lord, last part. The fixed deposits, your lordship got it. Page 20, your lordship may see the last part, that is C.
Hmm.
The fixed deposits 5 numbers belonging to the plaintiffs were also illegally adjusted against the housing loan by Sri Rampatlal Barma. Signature of Sampatlal Barma was forged in some documents very illegally, where Sri Rampatlal Barma also put his signatures, and the plaintiff hereby reserves the right to take appropriate criminal action. Now, when the allegation of fraud is made, in such a situation, it is beyond the scope of arbitrator. Assuming and under any circumstances, it can be given to the arbitrator, he cannot adjudicate that matter. Now, I'll take your lordship to a decision of the appeals court that is in decided in 2011 5 SCC 532. The lordship may see paragraph 29 and 33. Paragraph 29, my lord, your lordship may look at.
Yes.
Though section 8 does not prescribe any time limit for filing an application under that section, and only states that the application under section 8 of the Act should be filed before submission of the first statement on the substance of the dispute. The scheme of the act and the provision of the section clearly indicate the application thereunder should be made at the earliest. Obviously, a party who willingly participates in the proceedings in the suit, subject himself to the jurisdiction of the court, cannot subsequently turn around and say that the party should be referred to arbitration in view of the existence of an arbitration agreement. Whether a party has waived his right to seek arbitration and subjected himself to the jurisdiction of the court depends upon the conduct of such party in the suit. Then paragraph 33. But where the issue of arbitrability arises in the context of an application under section 8 of the Act in a pending suit, all aspects of arbitrability will have to be decided by the court seized of the suit and cannot be left to the decision of the arbitrator. Even if there is an arbitration agreement between the parties, and even if the dispute is covered by the arbitration agreement, the court where the civil suit is pending will refuse the application under section 8 of the Act to refer the parties to arbitration if the subject matter of the suit is capable of adjudication only by a public forum, or the relief claim can be granted by a special court or a tribunal. So therefore, my lord, here it's a case where your lordship will not find any arbitral clause in arbitration agreement. Now, in the absence of that, at the first place, my lord, in terms of 42C, by operation of law, the partnership agreement has been dissolved. And the moment it is dissolved, the clause enumerated in the partnership agreement, that also goes. Now, apart from that, my lord, these persons in the respondent's hearing, they are not a party to this partnership deed. And furthermore, my lord, they are not signatory to that partnership deed. Now, the appeals court, my lord, most recently, my lord, possibly on 20th September 2024, in a judgment that is in Ajay Madhusudan Patel, my lord, Justice, Honorable Chief Justice Chandrachud and others, they have passed a judgment that if any disputed question of fact it is there, whether it should be referred to the arbitrator or not, is totally a question, my lord, the civil court will decide whether there is an arbitration agreement or not. Here, there is no arbitration agreement. Apart from that, my lord, your lordship will very important fact that dispute can be referred to the arbitrator if all the parties are signatory to the arbitration agreement. My lord, this decision was held in 2003. Now it is upheld by the Supreme Court recently by the 3 judges. They have said, my lord, by conduct, if you are not signatory to the arbitral agreement, by conduct, if any person submits to the jurisdiction of the arbitrator, well, that can be taken care of. Now, here your lordship has seen, this person have filed a commercial suit. He did not submit it to the jurisdiction of the arbitrator. Now, these will have to be decided by the commercial suit in a public forum. My lord, because the arbitral forum is not a public forum, it's a private forum. Now, when it is a right in rem, it is always better to be adjudicated by the public forum. Therefore, suit which is pending there, well, it is up to that court, he will decide it. And your lordship has seen there is an allegation of fraud and all that, which cannot be decided by the arbitrator at all. It is beyond their competence to decide that. So therefore, my lord, there is another decision on that line, but I think these are keen to all that. So I think, my lord, on the basis of this decision, your lordship may dismiss this appeal because there is no legal issue to be adjudicated. Therefore, my lord, believe that it's a case where they could not primarily establish the case that it should be referred to the arbitrator on a first thing that there is no arbitral agreement, and therefore there is no point that it could be referred. And the judgment,
there is arbitration, there was arbitration clause in the partnership deal.
partnership deed by the erstwhile partners, and that has, my lord, it has been dissolved. Now, these persons, they are not signatory to those partnership deed. So therefore, there is no way out, my lord, it should be referred in terms of section 8 of the Arbitration Act. Because Arbitration Act has 8 has completed that they must, my lord, annex the original copy of the arbitration and or certified copy of that. And they haven't, they could not submit because it is not there. Therefore, is the matter, my lord, your lordship is required to dismiss this appeal as there is no prima facie case at all. That's all, my lord.
But Mr. Secure learned counsel
My
for
lord,
the
my senior is on let's lots of may take up after some time, my lord. We want to give reply, my lord, what the senior friend has submitted, my lord.
Acha.
Because my lord, he said some things which goes to the root of the matter, my lord. Because my lord, although the prayer is made for extension of time for submission of written statement, my lord, that is not the first statement of defense, my lord. There is judgment to that effect, my lord, which says that only praying for extension of time is not the first statement of defense, my lord.
My lord, your lordship, I withdraw from that submission, my lord. Even otherwise also your lordship can dismiss it on the point of law. My lord, he is saying that I have placed this statement there in page 44. My lord, I am not arguing that. In page 44, paragraph 11. Because they have filed an application on 26/4/2024, praying for adjournment to file a written statement on latter date. My lord, if they have to make any argument on that, well, I will not argue that. It's a matter of record, your lordship can look into it. Because the appeals court has said, when you submit to the jurisdiction of a particular court, then you cannot turn around and say that it may be referred to the arbitrator. That is the question of law, my lord.
Yes, Mr. Gupta.
My lord, since my senior friend is not sticking to that issue, my lord. Otherwise, there is a judgment, my lord. I am relying that year 2017. Yeah, 2017 Supreme Court 120. My lord, here paragraph 12, my lord. Supreme Court. Yeah, 2017 Supreme Court 120. Paragraph 12, my lord. May I read, my lord? In view of the law laid down by this court, as above, we find it difficult to agree with the High Court that in the present case, merely moving an application seeking further time of 8 weeks to file the written statement would amount to making first statement on the substance of the dispute. In our opinion, filing of an application without reply to the allegations of the plaintiff does not constitute first statement on the substance of the dispute. It does not appear from the language of subsection 1 of section 8 of the 1996 Act that the legislator intends to include such a step like moving simple application of seeking extension of time to file written statement as first statement on the substance of the dispute. Therefore, in the facts and circumstances of the present case, we are unable to hold that the appellant by moving an application for extension of time of 8 weeks to file written statement has waived right to object to the jurisdiction of the judicial authority. So, my lord, we have only prayed for extension of time for filing the written statement, madam. So by submitting that application, we are not submitted to the jurisdiction of the court, madam. And my lord, with regard to the, my lord, the senior friend has submitted that, my lord, there is a allegation of fraud, madam. Lordship, may kindly see the, my lord, plaint. What is the prayer in the plaint? Lordship has already seen, my lord, but I'm just repeating, madam. Page 23 is the prayer, my lord. Lordship has already seen, my lord. I'm just repeating, my lord. What are the prayers, my lord? Page 23, my lord. My lord, the first is with regard to dissolution, my lord. Second, my lord, it is with regard to declaration that the plaintiffs are entitled to half share. Then C is also, my lord, the half share of the plaintiff arising of the surplus. D is, my lord, appointment of receiver. E, my lord, decree of mandatory injunction. F, my lord, perpetual and mandatory injunction. And, my lord, cost of the suit, etc., my lord. So nothing is played, my lord, by saying that there is a fraud, my lord. Only some statements are made, but there is no prayer, my lord. So the issue is not with regard to prayer, and my lord, with regard to submission of the arbitration agreement, my lord, partnership deed is already there, my lord. And my lord, the partnership deed is already admitted by the plaintiff, my lord. They are not denying, my lord. Their whole case is based on the basis of this partnership deed, my lord. And my lord, with regard to death, they are saying that they are not the signatory of the agreement, my lord. Lordship may kindly see, my lord, section 40 of the Arbitration Act, my lord. 40, my lord.
Yes.
Arbitration agreement not to be discharged by death of party thereto. An arbitration agreement shall not be discharged by the death of any
No,
party.
Mr. Gupta, there was no arbitration agreement. It was only arbitration clause in the partnership deed.
Yes, my lord, there is clause, my lord. My lord, here, my lord, the clause is there, my lord, which says that if there is any
This
dispute.
section refers to arbitration agreement.
Yes, my lord, but here there is a clause, my lord, a specific clause with regard to arbitration, my lord. So it says, my lord, an arbitration agreement shall not be discharged by the death of any party thereto, either as respects the deceased or as respect any other party, but shall in such event be enforceable by or against the legal representative of the deceased. Number two, my lord, that is with regard to mandate, my lord. The mandate of an arbitrator shall not be terminated by the death of any party by whom he was appointed. Number three, my lord, nothing in this section shall be affect the operation of any law by virtue of which any right of action is extinguished by the death of a person. So if, my lord, it says, my lord, even if by death of a party, the arbitration agreement or clause will not, my lord, wiped out, my lord.
This section refers to arbitration agreement,
Agreement,
not refers to arbitration clause.
My lord,
So can it be applied to the case?
my lord, my submission is yes, my lord, because my lord, here there is a partnership agreement where there exists a partnership clause, my lord. There is no separate agreement, but clause is there, my lord, which covers the entire issue, all the disputes, dissolution and everything, my lord. And my lord, in this regard, my lord, I'm relying on one of the judgment, my lord. AIR 2007, AIR 2007 Supreme Court 1517. And here the relevant para will be from paragraph 21 to 27. Now. It starts from 19, Mal. I'm sorry, Mal, from 19. It starts from 19, Mal. May I read, Mal? It is clear from section 40 of the Arbitration Act that an arbitration agreement is not discharged by the death of any party thereto, and on such death, it is enforceable by or against the legal representatives of the deceased. Nor is the authority of the arbitrator revoked by the death of the party appointing him, subject to the operation of any law by virtue of which the death of a person extinguishes the right of action of that person. Then, Malo, section legal representative is defined, Malo. Then paragraph 21, Malo. The definition of legal representative become necessary because such representatives are bound by and also entitled to enforce an arbitration agreement. Section 40 clearly says that an arbitration agreement is not discharged by the death of a party. The agreement remains enforceable by or against the legal representatives of the deceased. In our opinion, a person who has the right to represent the estate of the deceased person occupied the status of a legal person. Section 35 of the 1996 Act, which imparts the touch of finality to an arbitral award, says that awards shall have binding effect on the parties and persons claiming under them. Persons claiming under the rights of a deceased person are the personal representative of the deceased party, and they have the right to enforce the award and are also bound by it. The arbitration agreement is enforceable by or against the legal representative of a deceased party, provided the right to sue in respect of the cause of action survives. Then, my lord, paragraph 27, my lord. We are of the opinion that in view of the provisions of section 46, read with section 48 of the Indian Partnership Act, as well as section 40 of the Arbitration Act 1996, the application for appointment of an arbitrator under the arbitration clause of the partnership deed. Here also, my lord, there was deed, my lord. Clause of the partnership deeds were liable to be allowed, and the learned Chief Justice has erred in overlooking the said provisions. While right to sue for rendition of the account of partnership firm survives on the legal representative of the deceased partner, he is also entitled to invoke the arbitration clause contained in the partnership deed. In the instant case, the appellant being the only son of his deceased mother, undisputably a partner in the partnership firm, with the respondents especially where the dispute concerning the partnership affairs had already arisen already during her lifetime. My lord, here in this case also, my lord, there is one partnership deed, my lord, and there is also a clause for arbitration, my lord. Then, my lord, application under section 11 of Arbitration Act was filed for the appointment of arbitrator, my lord. Then, my lord, that was rejected, against that this was filed. And, my lord, in the partnership deed, my lord,
One more, I'll just. It was not expected to make, my lord, certain, my lord, statement which are not correct, just to mislead this court, my lord. The one thing, my lord, that has been said, we have not submitted the original partnership deed. Now, in our petition, you also will find page 38. But you will see page 39, the last line. Originally submitted. It has been wrongly stated that we have not submitted the, my lord, original as per condition B of the section 8. Then secondly, my lord, the arguments that have been advanced by the respondent is confining to the section 42 of the Partnership Act. But here is a question of, my lord, Arbitration Act. The trial court has found that section 40, the lordship may come to, my lord, the finding at page 55. The 10th line from bottom, my lord. 10th line from bottom, it starts with moreover. Moreover, the ratio laid down by the judgment furnished before the court also makes it clear, in view of section 40 of the Arbitration and Conciliation Act 1996, the date of a party to a contract does not discharge the arbitration agreement between the parties.
No, that is the question I am putting.
Lordship.
Whether arbitration agreement and the arbitration clause are same. Here,
But
there is no
but two
arbitration
options.
agreement.
Section 7 says the arbitration agreement either by way of a clause in the commercial agreement or it can be a separate agreement. Now here is a clause,
Section?
section 7.
Yes.
Clause 2, an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Taking these few of the judgment I have placed, it has been clearly said that the commercial contract or the agreement is one thing and the this arbitration agreement or the arbitration clause providing arbitration is different. Notwithstanding the dissolution of the partnership, the arbitration clause or the arbitration agreement that remains. That is our case, and this also supports the if you takes up with the section 5, it starts to say non-obstante clause, notwithstanding anything.
Section 5.
Section 5. Notwithstanding anything contained in any other law for the time being in force in matter governed by this part, no judicial authority shall intervene except where so provided in this part. And this part, section 1 to 43, this is the part 1. So anything coming under this, it will override or exclude the application of the other laws. So therefore, reading between with the section 5 and section 40, clearly is noted the date of the parties, the arbitration agreement or the clause remains, and no other law will be applicable therein. The judgment two of the judgment which have been cited by the senior counsel is the same judgment which are relied on by the trial court, and both the judgments are relates only to the partnership. There is nothing mentioned with regard to the arbitration clause. The judgment of the Supreme Court that was referred to, as I have already submitted, the decree was passed while the defendant was alive. Execution case was filed. During that, the defendant died. Then the legal representative of the defendant said it is not executable. Since the partnership deed has been dissolved by the death of the party, so therefore it is not executable so far as the legal errors are concerned. And more particularly, it has been said that no benefit or whatever that has been taken thereof by the legal representative. Now here your lordship is that the entire plain based on the partnership deed. They are claiming, their whole claim is on the partnership deed, which also includes the arbitration clause. And after this amendment of section 8 in 2015, the 2024 judgment clearly states only the court will see whether there existed agreement of arbitration clause or not, or it is null and void.
Okay. Advisor, please just circle, learned counsel assisted by Mr. Gupta, learned counsel for the appellant, and Mr. S. Dutta, learned senior counsel assisted, learned counsel for the respondent. Argument concluded, order reserved.
But the proceeding is pending, that at least may kindly be stayed till the judgment is passed.
No,
But
no,
at this stage, your lordship has heard the matter.
yes.
There is no question of, staying
No,
the
no,
proceeding.
very soon we will pronounce the
Yes,
order.
yes. And your lordship, can you just one line and telling?
Yes,
Their case will fall to the ground if your lordship look at section 7, subclause 4. Arbitration agreement is in writing if it is contained in document signed by the parties. And your lordship, the so-called partnership deed, your lordship has seen that these Rahul Barma, he is not a party to it. The parties are Shampath Lal, Rampath Lal, then Lal Mati. Now, 7 is not attracted. 7-4 is, my lord, is not attracted. They will have to be party in the arbitration. If it is treated to be an arbitration agreement.
In this, my lord, just a short reply, the trial court has found there is a valid arbitration clause and also found that the dispute is arbitrable. But only the intrigue question that has arisen under, in the petition under section 8, the trial court would be the appropriate form. That is the finding. And whereas, my lord, I have already said, my lord, the senior division, civil judge senior division is without any authority, without any jurisdiction. This is the judgment of our court, my lord, and again, my lord, 2012 judgment is there. I'll supply that also. Okay.
Timing item number 10, promotion.
Made me, my lord, this civil division petition against an interlocutory order, my lord. Was by the additional district and session judge, my lord, no down, which is at page 20. The brief fact is this, my lord, in this case, the wife has filed one divorce case against the petitioner. And in this case, under section 24, one petitioner was filed where the honorable court, my lord, allowed a maintenance at a rate of rupees, my lord, 8,000 at page, my lord, page, paragraph 12, paragraph 12 of the court order, my lord. May I read, my lord? In view of the above discussion, I am of the opinion that it will be just and proper to direct their husband to pay rupees 8,000 at the rate of rupees 3,500, rupees 2,500, and rupees 2,000 per month to the wife and the elder daughter and the youngest daughter, respectively, for their maintenance until further order in this regard, direct effort. Apart from the above, the petitioner's wife is further found entitled to rupees 600 per month towards expenses of the present proceeding. Hence, he is directed to pay her said amount cost of litigation. And this amount was directed to pay 14, paragraph 14. The husband is directed to pay the year rent starting from the month of August 2022 onwards within a period of 4 months from today. The current maintenance amount and expenses of the proceedings shall be paid regularly every month. The husband shall deposit the above amounts, including expenses of the litigation of aforesaid in bank account of the wife. This is the thing, my lord. This is the second, my lord, maintenance. The first maintenance was under section 25, 125 of the CRPC, which is at page, my lord, at page 33. Page 33, this was passed by the judicial magistrate, first class of, in MR case number 48 of 2021. Relevant portion is at my lord. If you also kindly go to the relevant portion, you also will find at page 40, second paragraph, page 40, second paragraph. Considering as such, after hearing prima facie, it appears that being wife of the second party, there is domestic relationship between the parties facing trouble. First party has to leave her matrimonial house. It has prima facie appeared that the first party is in need of maintenance for first party, has no source of income. Considering the facts and circumstances of the second party, Sanjeev Hazarika is directed to pay sum of rupees 4,000 per month to the first party as interim maintenance for herself, along with 2,000 each for their 2 minor daughters. So total 8,000. It was earlier, my lord, on 1/2/2023. Accordingly, this petitioner was paying this money, my lord. But
as your lordship may kindly note that in the second order, the petitioner has not, my lord, filed any as per requirement of the Honorable Supreme Court's order, any assets and liabilities, which is, my lord, in Rajnish person Neha, my lord, as was reported in 2021 to SCC 324, not file any assets and liabilities, neither party. But this petitioner, in his written statement, has clearly stated that the liability, what is his liability, which is, my lord, at page, my lord, 88, page 88. Starts from 87, paragraph 27, 25, my lord. That the income of the respondent is concerned, second party is presently drawing this pay of rupees.
You are referring to paragraph number?
Paragraph number 25, at page 87. This is the statement given by the husband, my lord, before the trial court in his matrimonial divorce case, my lord. 25. Income of the respondent is concerned, second party is presently drawing a sum of rupees 46,723. It is important to mention here that the second party secured a loan of rupees 15 lakhs to construct a house in the year 2018 with a high hope that they will lead to a happy conjugal life in the said house. Besides that, financial assistance of rupees 3,50,000 in the form of personal loan was obtained in order to complete their dream house, but unfortunately she, with a view to live separately in her own style, lived matrimonial house, and thereby she ruined the life of the second party respondent. The housing loan, personal loan obtained just to give comfort to the first party and his minor children, but she, with her ulterior motive, without the knowledge of the second party, left the company. And
Now, what is your point, Mr. Goswami?
First of all, my lord, the requirement as per the order of the Supreme Court, my lord, the assets and liability was, the statement was not given. And secondly, my lord, this wife is living separately in adultery with another person. That name I have given, and the wife of that person lodged one FIR, which is, my lord, at page 58. Page 58. That wife.
No, you show me how the impugn order suffers from any illegality.
No, my lord, it is too high. It is total 16,600. But his statement, from this statement, it appears that after paying his liability of the loan amount, and that it's not possible for him to pay the 16,600.
But the learned court had taken note of the decision of Rajnish versus Neha.
Neha, but not the entire one. Not the entire one. At page, lordship may kindly pay. Page 70, paragraph, my lord. In that case,
okay,
paragraph 72.
Let notice go at this stage.
Yes, my lord, but I would pray.
No interim, no interim. You have to pay maintenance.
The maintenance, my lord, earlier we have been paying 8,000 per month. Now it is 16,000 is too much, my lord, 16,600.
We'll see. Let the other side enter appearance. We will consider your interim pair. Heard Mr. R. Goswami, learned counsel for the petition.
No, my lord, this requirement under this Neha versus my lord, Jitesh Sharma. Here, my lord, their requirement is.
No, the matter is yet to be finally adjudicated. The court may
But they have
consider
not
it at
filed
the
it.
time
No,
of final hearing.
it is necessary to file along with the petition. They have not submitted this assets and liability position because
Okay.
she is, my lord, earning sufficiently because she has a meat shop. She has another.
Mr. Goswami, let the other side enter appearance. This application under section 220 under article 220. Petition of India, read with section 151 of the CPC is prepared by the petitioner. Challenging the correctness or otherwise of the order dated 18/3/2024 passed by the learned additional decision number 2, Nagaon. In Mijje case number 27 of 2022, in Matrimonial divorce case number 44 of 2021. It is to be noted here that by the impugn order, the learned trial court has directed the petitioner to pay maintenance at the rate of rupees 8,000 per month to the respondent and her two daughters. Having heard the submission of Mr. Rusami, learned counsel for the petitioner, I have gone through the petition and the documents plus on record. Then also the order dated 18/3/2024. Let notice be issued to the respondent returnable in 4 weeks. The register post with ID and also the legal process. Well, this is the matter after 4 weeks. Interim pair will be considered only after appearance of the respondent.
Lordship, will kindly fix a date after 4 weeks, any date below.
After 4 weeks. On 1st November,
1st November,
sorry, on 4th November,
4th November. Obliged.
item number 23.
May it please the matter. In this case, senior counsel Mr. B. Dutta is appearing. He is on leg in another court. Can it be taken after some, can it be taken on some other day? Your Lordship?
As agreed by learned advocate for both sides, recess of this.
Interim to continue, Your Lordship. Interim to continue.
When do we want?
24/10, Your Lordship. He'll be here personally.
If it is a interim order is there, so only after vacation.
24/10, Your Lordship, that's after vacation.
Till an interim order pass earlier shall continue.
Highly obliged.
24th.
Yes.
Mixed lordship. My lord, in this case, my lord, the petitioner society, the last society registered, my lord, they wanted to start a new teachers education for B.Ed and BSc B.Ed, BP B.Ed courses, and applied for the under the National Council for Teachers Education 2014 regulation. And under this, my lord, we have submitted the application before the Guwahati University for 2023 March 22. Then on during the process, my lord, on 24/5/2022, that means after 2 months, the Executive Council resolution was passed on 29/3/2020, which was sent to us, my lord, and it says that the university will not give no objection certificate unless the government of Assam gives a no objection certificate first. This impugn order was in violation of the guidelines stipulated in Regulation 2014 of the Central Act. That is, my lord, national. Your lordship will go to.
But Mr. Burak,
My lord, last order you will see. Last order, it was there that the court will consider about the
interim pair.
interim pair. That is why I'm.
That's all right, but the other side is absent. Wait for some time, he informed the council.
25.
What go? Yeah? Okay, but Your lordship.
Yes.
Lordship, kindly look at the last order, lordship. Lordship, the elementary education was directed to file an affidavit, lordship. I haven't filed yet.
May I please, your lordship? Extra copy is not charged, lordship. Item number 25.
So heard, Mr.
Use here.
Learned counsel for the petitioner and Madam for learned standing counsel for respondent number.
All the respondents, lordship.
For all the respondents. Ms. Moore submits that she has not been furnished with extra copy of the petition. Accordingly, it is provided that learned counsel for the petitioner shall furnish a copy of the petition to Ms. Ward during the course of the day. The learned counsel for the petitioner, referring to order dated 6/3/2024, submits that the standing counsel to the elementary education is to file affidavit before date fixed. But the same has not yet been filed. So when you are going to file the affidavit?
After receiving extra copies, lordship, maybe 4 weeks.
Having considered the submission of learned counsel to both the parties and provided that affidavit shall be filed before the next deadline, at least after 4 weeks. After 4 weeks, for sure.
I mean 24.
I have filed an affidavit on behalf of Guwahati University, the respondent. Today itself.
Today,
Without that affidavit, your lordship will consider that affidavit. I have already answered the contents of that affidavit in my petition. And I will today confine my argument only on a legal point. If your lordship convinced that a interim order is required to be given, your lordship will consider.
the affidavit filed by them is not available before this court.
Yes.
Let us fix a short date on Thursday then. Or Mr. S. A. Buragway, learned counsel, senior counsel, assisted by Mr. learned counsel. You are for respondent number?
I am for respondent number 1 and 2, Guwahati University.
Respondent number 1 and 2. Mr. Fokon submits that he has filed affidavit.
26th of today itself.
And the claim is not placed on record. Accordingly, it is provided that recess shall list the matter on Thursday, enclosing the affidavit filed by the
Number 3 months. I'm for number 3 months.
respondent number 3. Okay.
Most of them. My lord, only one clarification, my lord. My learned friend has filed the affidavit in 4212 to their attempt 26, my lord, not this case.
Yes, 26.
26 he has filed. I'm with 24, my lord.
My lord, 24 and 26, both are analogous.
Not analogous.
So, my lord,
Yes,
the affidavit.
Whether one affidavit will serve the purpose or
My
not.
lord, since some documents are there, which are common documents. My lord, if this honorable court, my lord, directs my lord, will file another affidavit by tomorrow, my lord.
In 26.
26.
See, my lord, the fun. This court has said to file in 2024.
No, you have filed in which item, 26 or 24?
In 26,
WPT
we
number
have filed.
4212.
That is 26, my lord.
26.
This is, we are in 24.
In 24, you take down, taking note of submission of learned counsel for the parties. It is provided that Mr. Open shall submit, shall file another affidavit in connection with item number 20 by within a period of 2 days from today.
My lord.
On Thursday, we'll take both the matter.
Both the petitions.
27.
My lord, let it be in the next week, my lord.
Next week. Suggested that
Your lordship will add your lordship convenience. Tuesday,
27.
Tuesday.
Tuesday.
Yeah.
Okay, Tuesday.
First of all. First of all. तो की बात 1 अक्टूबर
27.
जब कपड़ों मुझे दिया मुझे भी टेंशन हो
Please, Your Lordship.
Yes.
My lord, we have filed affidavit in reply today itself, and we have served a copy.
It is not on record. Pardon me, sir, your good name?
A.K. Roy.
A.K. Roy, learned counsel for the petitioner, and Mr. Gupta, learned counsel for the respondent number.
All the respondents.
Broadly, I am
Sorry.
for 4, 5. Secondary education is there also.
Madam,
I am for 4 and 5, my.
your good name?
S. Niyogi,
Yes, Navneet, learned counsel for the respondent
standing counsel,
number.
my lord. Secondary education.
The learned counsel for the petitioner submits that he has filed affidavit in reply to the affidavit in opposition submitted by the respondent number 123. 123. And the same is not placed on record. Accordingly, it is provided that this is list the matter on.
My lord,
What do you want?
the matter may kindly be fixed on coming Friday.
It relates to
Coming Friday or?
no admission related now to all of urgency.
Ma'am, my
I
lord,
have no objection, my lord.
my lord, it is related to admission of the petitioner in class 8 in Dehradun, so we have urgency.
Rashtriya Military Academy, you know, the sessions would perhaps start. That is why they have some urgency.
Okay, Friday we'll try.
My lord. My lord.
For hearing 28.
May it please, Lordship. Lordship, I have been languishing in jail for 952 days till today. It's 2 years, 7 months, 12 days. So, Lordship, I would like to take the ground of delay, inordinate delay, and also the independent witness not supported the seizure. PW2 is the seizure witness.
So how many witnesses have been cited till today, examined till today?
2 witnesses examined today and
Two.
within out of 5.
Yes, on the other day, we have called for the
Yes, so
evidence of PW2.
Lordship.
Any other ground?
Lordship, section 52 is not complied.
52.
52, Lordship.
But the question is, can this court look into this aspect at this stage while considering the bail petition? Compliance or non-compliance of section 52?
Lordship, in the inventory and seizure, it has been shown that it's actually the packet and container both have to be separated, weighted in separately, but it is not done as per the NDPS rules 2022.
It was separately not done.
Not done much. It's a page number before. Page number, Lordship, 17, Lordship. With boxes, it has been weighted with boxes, Lordship, not separately. Supreme Court has also granted bail Nizam Sheikh versus State of West Bengal for non-compliance of compliance of section 52A.
Where is the where is that judgment?
Not
Yes, Mr. Das, what is your submission?
Lordship, in my humble submission, I wanted to state that, Lordship, as it is stated that there is a delay, Lordship, the deposition of the PW1 was on 13/6/2024, and the deposition of PW2 is on 30/8/2024, Lordship. And moreover, the next date is fixed for 14/10/2024, Lordship, and there are 5 witnesses. And already 2 has been gone, 3 are there, Lordship. So in my humble submission, there is no delay, Lordship. It is going on. Moreover, Lordship, there is presumption of 29 is there, Lordship. Moreover, conscious possession, in his conscious possession, it is found, Lordship. And again, in the FSL report, it is positive test for methamphetamine and heroin's percentage in this FSL report, Lordship, 85.68. And moreover,
Submission of Mr. Roman is that provision of section 52 is not complied with.
Lordship,
What is your submission? Have you seen the requirement of section 52? Whether inventory was prepared or not? And where the sample was drawn, at the place of seizure or before the magistrate?
Lordship, I have not seen the record, Lordship. I have not seen the record, Lordship.
Go through it.
Lordship.
I have seen you sitting there since
Lord-
long.
Lordship.
Yes, you submit a judgment.
Lordship, actually, Nizam Sheikh judgment is not with me. And another judgment is Vaishak versus State of Kerala. The court bench of Kerala High Court has relied on this. And the Mangilal's case. And for delay, Dhiraj Shukla and Muslim Hussain.
No, that was while dealing with appeal. against conviction, the Supreme Court has dealt with the issue. My question is whether at the time of bail hearing,
No,
this court
Lordship,
can consider the same or not.
Kerala High Court has relied on in the bail only. Okay. So I will give you the Nizam's judgment also.
Okay. Heard Mr. Roman, learned counsel for the petitioner accused, and Mr. Das learned additional copy for the state respondent. Argument concluded, order reserved. Mr. Das, you go through the record.
29.
May opinion, Lordship. If CD not available.
CD not available. Mr. Das learned additional PP submits that he has not received the case diary. Accordingly, it is provided that on
25th, Lordship.
25th. In the event of failing to produce the case diary on that day, court will proceed to hear and dispose of this petition without producing the case diary.
Item 30.
CD not available.
From where CD will come?
Nogao. Kampur, Lordship. 26, Lordship.
6.
26.
26.
26.
So item for hearing under order 41, rule 2 CPC, item 31.
Lordship, we are newly engaged in this matter. Lordship, matter may be taken after puja vacation.
After puja vacation. Your good name?
K. Bharali.
K. Borale, learned counsel, appearing for the appellant, submits that she has newly been engaged and as such, she may be granted some time to go to the record. Here is accordingly allowed. This is the matter. After vacation, Mr. Gogoi, learned correspondent number
7, 11, 12, and 14.
are present. None declared for the rest of the respondent.
Item 45.
May please, my lord. This appeal is preferred, my lord, against concurrent findings. Appellant as a plaintiff, my lord. They filed a suit for declaration of right title interest, recovery of possession and injunction. The suit was dismissed. Against that, my lord, I filed an appeal. The appeal was also dismissed, my lord. And hence this present second appeal. My lord. So my substantial question of law, my lord, will find at page number 5. Two substantial questions of law. Non-consideration of my application under order 41, rule 27. It has been wrongly typed as 47, madam. And second substantial question of law with regard to perversity, madam. Well, I'll just put the facts of the case, my lord. My predecessory interest was, my lord, the owner of 3 bigha, 1 kotha, 3 lessas of land. My lord. And my predecessor in interest, they sold 1 bigha of land to the predecessor in interest of the present respondents, my lord, who were the defendants in the suit. So after selling, my lord, 1 bigha of land, out of 3 bigha, 1 kotha, 3 lessas, my lord, I had possession over 2 kothas, 2 bigha, 1 kotha, 3 lessas of land, that is the Schedule B plot of land. And the 1 bigha of land, that is the Schedule B plot of land. Now, in the year 2015, my lord, out of this 2 bigha, 1 kotha, 3 lessas of land, I was dispossessed from 1 kotha, 10 lessas of land, that is the Schedule B plot of land. So I am claiming declaration of right title interest in respect of, my lord, the Schedule C plot of land
and recovery of possession in respect to Schedule D plot of land, that is 1 kotha 10 lessors. Now, the core issues that involved in the suit was filed, whether I have right title interest over the Schedule C plot of land, and whether I'm entitled to get a decree for recovery of possession in respect of Schedule D plot of land. That has been discussed at page number 99. By the appellate court. Malatis got.
Yes.
Issue number 3, whether the plaintiffs have right title interest over the Schedule D land, and issue number 4, whether the plaintiffs are entitled to recovery of possession over the Schedule D land by demolishing and removing the illegal construction made by the defendant. The plaintiffs have claimed that their predecessor interest, late Moharam Ali, was the owner of 3 bigha 1 kotha 3 lessors of land described in Schedule A of the plain, and after death of Moharam Ali, the plaintiff number 1 and one of her sons, late Rohimuddin, sold their share of 1 bigha land to the father of the defendants, described in Schedule B of the plain. The plaintiffs have based their claim over the land owned by late Moharam Ali by virtue of basis of 3 registered sale deeds executed by late Abbas Ali in favor of late Moharam Ali in the year 1967 and 68. The defendants have not challenged the said sale deeds dated 15/5/1967, 16/5/67, and 13/9/68 executed in favor of the predecessor interest of late Moharam Ali of the plaintiffs. Instead, the defendants confirmed that late Moharam Ali purchased land measuring 3 bigha 1 kotha 3 lessors by way of 3 registered sale deeds, and after the death of Moharam Ali, the plaintiffs mutated their names in the records of rights, and thereafter the plaintiff number 1 and her deceased son, late Rahimuddin, sold 1 bigha land out of 3 bigha 1 kotha 3 lessors to the father of the defendants. It is seen that apart from the plaintiffs, pro forma respondent number 8 to 11 are also admittedly the legal heirs of late Moharam Ali, being his daughters. According to the plaintiffs, after selling 1 bigha land, the plaintiffs were in possession of 2 bigha 1 kotha 3 lessors of land described in Schedule C of the plain. The plaintiffs have alleged that the defendant disposes the plaintiffs from 1 kotha 10 lessors out of 2 bigha 1 kotha 3 lessors land, which is part of Schedule C land. This alleged enclosed Schedule D land is the suit land, and the plaintiffs have inter alia prayed for declaration of right title interest over 1 kotha 10 lessors of land, that is Schedule D land. On the other hand, the defendants denied exclusive possession of the plaintiffs over the entire 2 bigha 1 kotha 3 land, 3 lessors land, and claimed that their father, late Musaddar Ali, was in possession of the entire 3 bigha 1 kotha 3 lessors land even before he purchased the 1 bigha land and enjoyed the said land together with his brother Moharam Ali as joint family property. But although the defendants late claimed, the defendants also asserted that they are enjoying 2 bigha 1 kotha 3 lessors land as undivided property along with the plaintiffs. But although the defendants laid their claim over said 2 bigha 1 kotha 3 lessors of land by way of inheritance, the document shows otherwise. Further, the defendants did not adduce evidence to show their ownership of any kind over said 2 bigha 1 kotha 3 lessors of land. The plea of the defendants that they have shares in the said 2 bigha 1 kotha 3 lessors of land by way of inheritance remained a mere plea only. It's a fact that the plaintiff number 1, since deceased, and the father of the plaintiffs number 3, 4, sold 1 bigha land out of the total 3 bigha 1 kotha 3 lessors, which includes their share over the said land, to the father of the defendants before partition of the property amongst the legal heirs. The plaintiff is silent on the shares of the plaintiff number 1 and late Rohimuddin on 2 bigha 1 kotha 3 lessors of land after selling 1 bigha land to the father of the defendants. However, as the ownership of Moharam Ali over 3 bigha 1 kotha 3 lessors is not disputed, and the plaintiffs and pro forma respondents number 8 to 11 are admittedly his legal heirs, they are entitled to inherit his property. Thus, land measuring 2 bigha 1 kotha 3 lessors belongs to the heirs of late Moharam Ali, that is the plaintiffs, and the pro forma defendants number 8 to 11 by way of inheritance. Before deciding the right title interest of the plaintiffs over the suit land, that is 1 kotha 10 lessors of land described in Schedule D, it is necessary to determine whether the defendants constructed RCC structure on the suit land by exceeding their 1 bigha land on 11/8/2015. The description of Schedule D in the plaint is that the Schedule D is part of Schedule C land measuring 2 bigha 1 kotha 3 lessors. First of all, PW1, that is the plaintiff number 2, admitted that they have not measured the land to know about the exact area of land.
Okay, Mr. Iqbal.
My lord. My lord, my only contention is that, my lord, since the 1 bigha of land is purchased from the 3 bigha land, the schedule that is given in the sale deed on the northern portion, my lord, that was wrongly given. it ought to have been the land of the plaintiffs, but by mistakenly, my lord, it has been written that land of Fayaz Ali is there. And in fact, the defendants have also admitted in the cross-examination that in the northern part, plaintiff is there, my lord. But the learned trial court, both the trial court as well as the appellate court did not take into account, my lord, this vital aspect of the matter. And this goes to the root of the fact, my lord. And that's why, my lord, I filed an application under Order 41, Rule 27, so that, my lord, to appoint a commission so as to ascertain, my lord, what is the exact amount of land that I am inheriting and what is the exact area of land they are possessing.
When you have filed that application?
Application, my lord, I had, it is not there, my lord, I have.
At what stage you have filed that application?
Appellate stage, my lord. Order 41, Rule 27, to file additional evidence.
So this is the substantial question is based on this document and you have not enclosed this document with the appeal.
My lord, that was my mistake.
You file it by way of additional affidavit.
My lord, but the discussion is there, my lord.
Maybe.
The appellate court is not at all discussed, my lord. It has said that the suit land is not identifiable.
Recessal is the matter on Friday.
Friday.
So as to enable him to file an additional affidavit bringing on record the application under 630 review order 41 group 27 of SCPC review 612 filed before the learned first appellate court.
Of orders,
Objection.
number 33.
May I please your lordships? I am appearing on behalf of the appellant, my lord. While the office note dated 29/2024, my lord, neither AD card nor unserved notice has been received for respondent number 2, my lord. And LCR has been received, my lord.
So what to do? You want to take precedence upon respondent number 2?
My lord, service can be awaited, my lord.
Awaited. You are for respondent number 1.
Respondent number 1.
Pardon me, sir, your good name?
S. Sanchiti, my lord.
Learned counsel for the appellant and Mr.
S.
Learned counsel for the respondent office note dated 28/9/2024 indicates that service report in respect of respondent number 2 is still awaited. List the matter after 2 weeks, awaiting service report of respondent number 2.
Hello, please, my lord.
34.
May I please, lordship, in this case, in respect of respondent number 3 expired, other respondents appeared. So his estate is represented by the other respondents, lordship. So his name may be struck off, lordship.
Pardon me, sir, S. D. Purkesto, learned counsel for the appellant and Madam Roy, learned counsel for the respondent number
3.
I am for the respondent number 1, 3, 4, 5, 6, and 7.
1, 3, 4, 5, 6, and
Oh, sorry,
7.
1, 2, 4, 5, 6, 7.
1, 2, 5, 6, and 7. Office note dated which one? 19/6.
Lordship.
Office note dated 19/6/2024 indicates that service report in respect of respondent number 3 is still awaited.
No, no. There's a report regarding it.
Actually, Miller, respondent number 3 died long back before passing of the appellate court judgment. He died on 11/4/2021, Miller.
But the laws in my court has observed that he had gone out of station.
Yes. Subsequently, it came also it expired.
Is there any office note to that effect?
Office note dated
20.
29, 20.
What's that? Process server report. Okay. Office note dated 29/2024 indicates that respondent number 3 indicates that as per report of the process server, respondent number 3 expired. Learned counsel for the appellant submits that
These are stated represented by the other respondents.
the state of the respondent number 3 is represented by rest of the respondent. And as such, his name may be struck off from the array of this appeal. Where is accordingly allowed at the cost and risk of the learned counsel for the appellant. The name of respondent number 3 may be struck off from the array of this appeal. List the matter for
Milord, in this case, LCR received and the respondent number 1 who is 90 years old. So your lordship may kindly fix the matter for hearing after puja vacation.
LCR is not received.
Yeah, LCR received, I have seen.
It is submitted at the bar that the LCR has already been received and the matter is ready for hearing. Accordingly, it is provided that recusal lists the matter immediately after reopening of the vacation. After reopening.
35.
In this case, the LCR has been received and respondent number 1, 2, 3, and 4 have appeared. And service upon respondent number 7 and 8. Performance.
They file the IA for issue of the judgment. So I have not received a copy of the IA.
I'll show you.
And the matter may be taken after vacation to the vacation.
Service completed in the
Regarding
appeal.
respondent number 5, 6, 7, service is not complete. They are not necessary, lordship. They may be struck off. But I think
1, 2, 3, 4.
Government also there, but not reflected in the cause list.
We have taken steps. I'll serve extra copy to the government. And respondent number 5 may be struck off, lordship.
5N?
Lordship.
5N?
Only 5. 6, 7, 8 may be represented by the state government administrator.
And 9?
9 service complete, but he has not appeared.
Okay. Third Mr. So learned counsel for the appellant. And Mr. your good name?
DA Kayum.
Learned counsel for the respondent number
1, 2, 3, and 4.
3 and 4, and Mr. Gogoi for respondent number 6, 7, and 8.
6, 7, 8.
7 and 8.
6.
6, 7 and 8. Our names will be reflected.
Mr. Gogoi, learned counsel for the respondent number 6, 7, and 8 submits that the name of the government advocate has not been reflected in the counsel summons. Rest shall do the needful in this regard. The learned counsel for the appellant further submits that the name of respondent number 5 may be struck off from the array of this appeal. Why his name has to be struck off?
5 is deed writer. Respondent number 5 is the deed writer. And only the appellants contested the suit. Rest are will perform.
So no relief is being claimed against him.
No.
The learned counsel for the appellant submits that respondent number 5 is only a deed writer, and he has not contested the suit, and no relief is also being claimed against him, and as such his name may be struck out from the array of this affair is accordingly known that the cost and risk of the learned counsel for the appellant, the name of respondent number 5 may be struck out from the array of this appeal. Mr. Gogoi submits that he has not been furnished with the copy of this memo of appeal and also the copy of the IA. Accordingly, it is provided that the learned counsel for the Appellant shall furnish a copy of the memo of appeal and also the copy of IA to Mr. Gogoi and also to Mr. Learned counsel for the respondent number 1, 2, 3, and 4 during the course of the day. Place the matter after when? After vacation.
36.
Made preservation. My lord, record was called for, it was not received. Then last occasion, my lord, your lordship directed remainder. Remainder. What's up?
LCR received by email.
It is received, my lord. Sir, it may be listed for admission, my lord. It's a simple matter, my lord. It was, appeal was dismissed for default. So after Puja vacation.
Notice served.
Notice, sir, my lord, all are represented.
So Gogoi, you are for?
I am for respondent of 4 laws.
For rest of the respondents?
My lord, your lordship would be pleased to see order
Superintendent of
dated
Taxes, Dhuburi.
14/8/2020.
Also,
All are served.
2 and 3 are good.
both the parties are
one
represented by
went,
the
no?
NDPS council. Office note dated 28/9/2024 indicates that LCR has already been received and the matter is ready for hearing. Admission hearing. Accordingly, it is provided that the SSL is the matter immediately after reopening of the vacation.
Obliging. Obliging.
38.
May it please lordship. Lordship needs some time to file affidavit in reply.
Second reply. Pardon me, your good name?
D Pathak.
Pathak, learned counsel for the petitioner, and Mr. Soikia
And for pension department matter, respondent number 4.
for the respondent number 4 and
I am for the secondary education matter.
for secondary education and madam
I'm for the accountant
One
general.
district.
Respondent
Anyone
number
district.
5.
for respondent number 5.
I'm representing 1, 2, and 3.
Representing 1, 2, and
Yes.
3.
Administration. Service to, administer service to,
Uh,
sir? Administer service to, sir? I see. Payment service.
Lordship, I have not received provisional pension, so that matter may be
Okay.
fixed kindly immediate
Learned
after
counsel for
Puja.
the petitioner submits that she may be granted some time. Affidavit in opposition filed by the respondent number
2.
Respondent number 2. There is according to the SSL is the matter when
Immediate after Puja vacation.
immediately after reopening of the vacation.
39.
Highly obliged.
My lord, in this case, in IA, my lord, notice was issued, but unfortunately, steps could not be taken in due course, my lord, so some time may be permitted.
Mr. Pal, learned counsel for the applicant submits that inadvertently he could not take any step upon the respondents and price for granting him some time. There is allowed. SSL is the matter after
Immediately after vacation, any date,
immediately after reopening.
any date may kindly, because they have to file response also, notice issued to them,
Okay, Madam, you are for
For the higher education
higher
department.
education, they have to file affidavit.
higher education department.
Let them file response as per earlier order of this court,
You have filed a response.
not filed.
You want to file?
Yes, lordship, this honorable court directed in last order to file affidavit in opposition.
The learned standing counsel for the higher education submits that she may be granted some time to file affidavit. Affidavit in this, There is a person to order dated 6/9/2024. There is accordingly allowed. List the matter on
Anyway, 27 or 8. 28,
before vacation may not be possible.
28/10.
Okay. But for rest of the respondents,
Yes, we are taking stress by tomorrow. I am for the petition.
if upon rest of the respondents shall be taken by registered post with AD and also by usual process in 2 working days from today.
Lordship may fix the date, right?
November.
28.
November.
My lord, it is a matter for, what date we fix, my lord?
5th November.
5th November. Obliged.
40.
May I please, Lordship?
Yes.
Lordship, as per the latest office note, the notice could not be served due to some inadvertent clerical mistakes, Lordship. So Lordship, I apologize for that, and Lordship, let the matter be taken up immediately after vacation, Lordship. By this time, the notice may be completed, Lordship.
Heard Mr.
N.M. Azerbaijan.
Learned Counsel for the petitioner, Mr. Nazarboya submits that due to some clerical mistake, step could not be taken upon the respondents and thus for granting time to take step upon the respondents, where is accordingly allowed. Step be taken by registered post with AD and also by usual process within 2 working days from today.
Lordship, there were some mistakes. I mean, steps have been taken, but due to the shortage of postal stamps, Lordships, that will be rectified within 2 days. Lordship.
Okay, the mistake shall be mistakes shall be rectified within 2 days from today. List the matter after 4 weeks.
Lordship, a date may be fixed after vacation, Lordship.
20 November.
Obliged, Lordship.
41.
This eviction is for a condemnation of delay, lordship. Delay is a 90 days, lordship. And it is first time listed. Lordship, at this stage, we are noticing.
Third means your good name.
At this I can.
Learned Counsel for the applicant. The application number section 5 of the litigation act 1963 is referred by the applicant for condemnation of delay of 90 days in filing connected appeal against the impugned decree and order dated 9/3/2024 passed in TS number D number 85 of 2022 by the learned additional district judge Belgrade. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also the process within a week from today. It's after 4 weeks.
46. 46.
Please check.
Yes.
Service has been completed.
Service
Has been completed.
completed. Art means your good name.
M. Devi.
M. Lily, learned counsel for the petitioner. And madam,
My lord, I am appearing for respondent number 3 and 4.
respondent number 3 and 4. None appears for the respondent number 5 and 6.
I am appearing for 1 and 2.
Is so learned counsel for the respondent number 1 and
2.
1 and 2. 1 and
Lordship may kindly fix the matter.
is submitted at the bar that service has already been completed and the matter may be listed for admission hearing. Accordingly, it is provided that registrar shall list the matter for admission hearing immediately after reopening of the vacation.
47.
May I please, Lordship? Lordship, in this matter, as per the latest office order, no, service has been already completed, Lordship. So, Lordship, let the matter be taken up on next Monday. There is some urgency, Lordship, because the property of the petitioner Madrasa has been taken over by the state respondents and they have been suffering to continue their regular functioning, Lordships. So Lordship may take up the matter on Monday next.
Lordship, here I'm appearing for the WMD department, my lord. I have received instruction, I may be allowed to bring in a record. Immediately after vacation, Lordship, Lordship may take up this matter. Lordship may kindly peruse my instruction for a moment.
Lord Mr. Mazhar Bhuiya, learned counsel for the petitioner and madam.
Lordship, I am for respondent number 2 and 5 for WMD department.
Number 2 and
5, my lord.
5 for respondent. For respondent number 2 and 5. Your good name, please.
MD Bora,
MD Bora.
standing counsel WMD department.
And you?
For 1, 3 and 7, madam.
1, 3 and 7.
7.
The learned counsel for the respondent number. Madam, you are for respondent number
2 and 5, my lord.
4 and 5. Summits.
2 and 5.
2 and 5 summits that he has received instruction. Written instruction. No, she has received paragraph comment and she may be granted some time to file. Pair is allowed. Rest is unless the matter after
Vacation.
immediately after reopening of the vacation.
May I submit, Lordship?
Yes.
Lordship, a date may be fixed immediately after vacation, Lordship,
Okay.
in the month of October, Lordship, kindly.
First week of November, my lord, we have to prepare the affidavit and send it for vetting also.
Okay,
After
Lordship.
the vacation, first week of November, my lord.
First week of November, any date, 4th of November, Lordship, may kindly.
I'm so deeply obliged.
You want to take it back?
My lord. Obliged, lordship.
For hearing, item 42,
Lordship, date.
6 November.
Obliged.
May I please have a motion? Here in this case, Lordship, this second appeal has been filed with the substantial question of law that there's a misinterpretation of the evidence and the Evidence Act of Section 101 of the Evidence Act. Now, what has happened in this case, Lordship, is there's a prolonged litigation. The first litigation was, in fact, is the title suit number 472 of 2009 that was filed by the predecessor of the present appellants, the Uma Chatterjee, for eviction. It is at page number 13, Lordship, Annexure 1. The suit was filed against Anup Thakuria.
First, let us see the substantial question.
Yes, Lord. The substantial question of law is at page number 10, Lordship.
Yes.
Lower appellate court is based on misinterpretation of the evidences and documents on record as such purpose, whether the learned lower appellate court had misconstrued the provision of section 101 of the Evidence Act, whether the learned lower appellate court passed the impugned judgment and decree in contravention of the provision of 4131, and whether the impugned judgment and decree of the learned lower appellate court are based on purpose finding, whether the learned lower appellate court has failed to take note of the vital legal proposition that merely by exhibiting an unregistered document,
No.
whether the respondent number 1 was successful in
From where you are reading?
page number 10, Lordship, of the memo people. Otherwise admitted on the first three substantial question of law.
Then,
Yes. I'm just reading the other, the substantial question of law.
so this appeal was admitted only on 3 substantial question of law.
Yes.
So you saw what is the misinterpretation?
Exactly, Lordship. Now, what has happened, Lordship, the suit was filed. The suit was filed for eviction eviction of the respondent number 2. This respondent number 2, the Anup Thakuria. He was the original tenant. That's why I'm just referring to the plaint. This is annexure 1, page 13. The suit was filed for eviction under section 5 of the Assam Urban Rent Control Act 1972 and also for realization of the area rent. Now, what has happened, Lordship, in this particular suit? The tenant appeared before the learned trial court and accordingly he had admitted the default on his part in paying the monthly rent. And on the basis of that admission, the concerned plaintiff filed an application for admission decree. Accordingly, the decree was passed and it is there at page number 23, Lordship, the admission decree.
Page number 23.
23, Lordship. The operative portion is at page number 5. I have gone through the pleadings of both the parties and also gone through the provision of order. Lordship, got it? Page number 23, Lordship.
Says judgment on admission.
Judgment on admission, Lordship.
Relevant paragraph is 5.
5.
Yes.
I have gone through the pleadings of both the parties and also gone through the provision of Order 12, Rule 6 and Order 15, Rule 1 of CPC. Order 12, Rule 6 provides that court may at any stage of the suit pass a judgment of the basis of admission made in the pleadings or otherwise. Order 15, Rule 1 of CPC provides that the first hearing of the suit, if it appears that the parties are not in issue or any question of law or fact, the court may at once pronounce judgment. In the instant case, the defendant categorically admitted that he had not paid rent for 2 months and also paid to pay the area rent in installment. The plaintiff in para 5 of the plaint stated that the suit premises required bona fide. The defendant in para 4 of the written statement stated that he has no comment in respect of the averment made in paragraph 5 of the plaint, which is otherwise is an implied admission on the part of the defendant. From the pleadings of the parties, it is evident that there is no triable issue in the suit. Defaulter and bona fide requirement are the grounds for eviction of a tenant under the provision of Assam Urban Rent Control Act. So on the basis of admission of the suit, the decree without cost. The suit is decreed on admission but without cost. So that was the suit was decreed. Now when the suit, that particular suit was decreed and the decree was put for execution, then the present respondent, if your Lordship kindly see, the present respondent by annexure 4, page 34. Filed an application under Order 21, Rule 97. Under Order 21, Rule 97. That application was on the ground that he was the tenant during the relevant period of time, but the decree has been obtained in a collusive manner. Lordship got it, page 34. The decree has been obtained in a collusive manner. So pausing for a moment, Lordship, the provision of Order 21, Rule 97 CPC, I'm just reading out this particular provision. Order 21, Rule 97 CPC is very clear, where the holder of a decree for the possession of immovable property or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any person obtaining possession of the property, he may make an application to the court complaining of such resistance or obstruction. Now, here in this case, he was not the purchaser or the owner of the property or the decree holder. He is no way connected with that particular property. He was claiming himself to be a tenant. So if he was claiming himself to be a tenant, he should have been filed a case under the provision of the Assam Urban Rent Control Act. But he did not file any application under that provision. He filed an application under Order 297, which is otherwise not maintainable. So we filed the objection, Lordship. It is page number 39, annexure 5. And in this particular objection, we have made a specific statement in the very first paragraph that the application purportedly filed under Order 21, page 39, Lordship.
Got it.
Under Order 21, Rule 97, read with Section 151 of the Code of Civil Procedure. By the objector of the decree herein referred, so as the objector is not maintainable and is liable to be rejected in limine. Now, in the third paragraph, we have mentioned that the bare reading of Order 21, Rule 97 of the CPC under which the present application has been purportedly filed indicates that the same can be filed by the holder of a decree on the face of a resistance or obstruction by any third party. So decree holder can file it, Lordship. Admittedly, the objector herein is not the decree holder, and as such, he does not have locus standi to file the application. The application, therefore, is liable to be rejected on the count alone. So that was the preliminary objection we raised with regard to the maintainability of the application because he was not the decree holder. Now, Lordship, the other relevant objection that has been raised. It is in page number 5. If your lordship kindly see, I'm just referring to paragraph number 5 at page number 40. That the statements made in paragraph 1 of the application claiming that the objector is a tenant of the predecessor of the decree holders and that he has been a tenant since the year 1991 with respect to the scheduled premises are not correct and the same are hereby denied. Fact remains that he is a tenant with respect to 1200 square feet on the second floor of the same building. However, in the year 1991, he had taken the suit premises on rent from the predecessor of the decree holder by executing a deed of tenancy on 1/4/1991, and the same was in force for a period of 3 years up to 31/3/1994. However, the tenancy continued till March 2005, and as the room was kept unused without any purpose, he handed over vacant possession of the suit premises in favor of the predecessor interest of the decree holder in the month of March 2005. Thereafter, Sri Anup Thakuria took the suit premises on rent on 16/5/2008 by executing written deed of rent agreement, and the same case came into possession of the suit premises thereby. As he failed to pay rent thereafter and became a defaulter, the predecessor interest of the decree holder instituted at a suit. So the objection that was raised by the decree holder is that during the relevant period of time when the suit was filed, the Anup Thakuria was the tenant in the suit premises. The present respondent was never a tenant during that relevant period of time. Now the evidence was laid in this particular case, lordship. Now the impugned order is at the trial court order is at page number 46, annexure 6. Annexure 6. Now the points for determination was there also, lordship, in page number 47. Lordship got it? Page number 47. The following points for determination were framed by the learned predecessor: whether the petition by the objector is maintainable, whether the objector is a tenant in respect of the suit premises, whether the objector is entitled to the reliefs claimed in the petition, to what relief and reliefs. Now, with regard to the maintainability, the first point number 1. The petition under Order 21 Rule 97 CPC is preferred by a third party claiming his long possession of the suit property as tenant. A third party in possession of a property claiming independent right over the decretal property can resist such decree by seeking adjudication of his objection under this rule as held by such and such 1998 SC 1827. The Honorable Supreme Court in the case of 1995 1 SCC has held that in the following words: the scheme of the court clearly adumbrates that when an application has been made under Order 21 Rule 97, the court is enjoined to adjudicate upon the right title interest claimed in the property arising between the parties to a proceeding or between the decree holder and the person claiming independent right title or interest in the immovable property. An order in that behalf be made. The determination shall be conclusive between the parties as if it was a decree subject to right of appeal and not a matter to be agitated by separate suit. Here in this present suit in hand, the objector of the decree is a tenant of the predecessor of the decree holders, late Uma Chatterjee, with whom an agreement was entered into in objector. The objector claimed that the decree of this suit is obtained by the decree holder by fraud and paying his right as tenant over the suit premises. Therefore, the present application is maintainable. The learned trial court, lordship, executing court came to a finding the application was maintainable under Order 21 Rule 97. Now the second point, point for determination, the objector, whether the objector was a tenant. Now the learned executing court came to a finding, lordship. I will refer to the evidence later on, lordship. The petitioner as PW1 deposed in his evidence that he has been a tenant under the predecessor of the decree holder, late Uma Chatterjee, by entering an agreement on 1st of April 1991. The decree holder entered another agreement on 10/6/1991, wherein it was shown that the tenancy exists since 1991, and the tenant continuously enjoying the suit premises, and the rent is regularly received by the decree holder from the petitioner. The electricity bills also paid regularly by the petitioner to the decree holder, and he is still a tenant in respect of the suit premises. During cross-examination of PW1, he deposed that he has taken the ground floor and the second floor on rent from the predecessor of the decree holder, late Uma Chatterjee, by defined agreement. The PW1 admitted that as regards the tenancy of 1/4/1991 to 10/6/2011, he has not submitted any tenancy agreement. This is important, lordship. There was no tenancy document exhibited by the objector. Further deposed that before 2013, petitioner has no tenancy agreement with the landlord. Exhibit number 4 is the rent paying receipts on December 2013. Apart from these exhibits, no other rent receipts are exhibited in this case to show that he has regularly paid rent prior to after 2013. The PW1 contended that the decree obtained by the decree holder is by way of fraud. However, the petitioner has not any single evidence to prove the effect of fraud or to factum obtained in the decree by applying fraud. It is pertinent to mention here in that the exhibit number 1 is the rent agreement between the petitioner and the decree holder entered on 10/6/2011. The petitioner contended that he has been a tenant in respect to the suit premises since 1991. However, he has admittedly failed to substantiate his claim by adducing the tenancy agreement entered in the year 1991. Further, exhibit 3 is the bank account passbook of the petitioner showing the payment of rent since the year 2011. Exhibit number 5 and 6 are the electricity paying bills in the year 2013. The petitioner's evidence is only confined to the year 2011 and 2013, and there is nothing on record which shall establish the contention of petitioner that he has been a tenant since 1991 under the decree holder, and as such the decree obtained by fraud without informing the tenant of the suit premises. If we balance the preponderance of probability, I find that it is more favor of the decree holder. The petitioner is miserably failed to establish the contention as averred in the petition. So that aspect of the matter with regard to the claim that he was a tenant, he was the original tenant under the predecessor of the appellant, that was discarded by the executing court. Now, in view of the above discussion, I hold that the decree is executable under the present petitioner. The decree holders are intended to recover vacant possession of the premises by evicting the petitioner objector. So this is the final outcome, lordship, and the point number 3 and 4 are decided accordingly. This case is dismissed. So that application which was filed under order 21 rule 97 lordship, that was dismissed. Now the respondent preferred an appeal against that particular order, judgment and order. And this appeal, lordship, is the impugned in this present second appeal. It is at page number, starting from page number 55, lordship. The operative portion is at page number 57. Lordship, got it. Page number 57. Whether the petition by the objector is maintainable because the trial court held that it is maintainable. Now the next point is that whether the objector is a tenant in respect of the suit premises under the decree holder. With regard to that aspect of the matter, lordship, the learned trial court joined both the issues at page number 51, issue number point number 1 and 2. It is at page number 59, lordship, and accordingly illustrated the entire aspect of the matter and passed the impugned judgment and decree. I'm just referring to that particular portion, lordship, the issue number 1 and 2. As both the issues are interrelated, so they are taken up together for discussion. The materials available on record disclose that the appellant set the justice delivery system in motion by filing a petition claiming that the decree holder, in collusion with the judgment debtor, fraudulently obtained decree from the trial court as the suit premises in respect of which decree and eviction order has been obtained is in the possession of the appellant in the capacity of a tenant since 1991. In pursuance of his long-standing landlord-tenancy relationship with the predecessor of the respondent number 1, and subsequently with the respondent number 1 by tenancy agreement of 2011 marked as exhibit 1. It is further alleged that Anup Thakuria, judgment debtor, is a stranger to the suit premises, and the bailiff of the strength of decree want to evict appellant from the suit premises, who is the original tenant and occupied the suit premises, and for which he was compelled to take the shelter of this court for seeking justice. The appellant, in order to substantiate his claim, also exhibited his rent agreement dated 10/6/2011 as exhibit 1, wherein it appears the facts regarding landlord-tenant relationship in respect of the said suit premises by appellant with the respondent or the predecessor of respondent since 1991 is shown to have been admitted. Further, if we pursue the exhibit 1 meticulously, we will find that it is a notarized document, so a statutory presumption of its due execution of the light of section 114 illustration E of the Evidence Act would arises in favor of the appellant. However, it is contended by the respondent the aforesaid rent agreement is a fraudulent document, as appellant had allegedly exerted mental pressure upon the respondent while he was in a state of unsound mind and fraudulently obtained his signature under some blank paper and had converted the same into rent agreement. Now, if that be a position, then in my considered opinion, the burden of proof as to the aforesaid alleged creation of fraudulent document and as regard unsound of mind of the defendant at the relevant point period lies upon the defendant in view of provision laid down under section 101, 102 of the Evidence Act, when defendant had vehemently put his signature over the disputed document. But if we peruse the evidences available on record, we will find that there is no iota of evidence from the respondent decree holder side to establish the aforesaid fact, nor there is anything to suggest as to how the appellant has come to the possession of the suit premises at the relevant point of time when the bailiff of the court visited the suit premises for eviction of the Anup Thakuria, if he is not a tenant. Further, there is also nothing to suggest as to how he remembered the fact that appellant has exerted mental pressure upon him when he was allegedly mentally ill. We know that a mentally ill person, a person of unsound mind, is not expected to have knowledge of anything, and he is not expected to distinguish between what is mental exertion and what is not. Now, if the respondent claims that the appellant has exerted mental exertion and fraudulently obtained signature in blank paper, then I have the considered opinion that it is highly improbable that respondent was not in a proper state of mind while he put his signature over the disputed document. Further, his silence as regards alleged creation of fraudulent deed for such long period of time without informing about the aforesaid fact to his near and dear ones or to police create serious doubt over his claim. So under the aforesaid facts and circumstances, I have the considered opinion that the facts alleged by the defendant is erroneous and hence this case stands disproved. In consequences, I am the constraint to hold that notarized rent agreement coupled with the possession of the appellant over the suit premises established the fact that there was allegedly landlord-tenancy relationship between the appellant and the predecessor respondent since 1991 and subsequently with the respondent number 1 by virtue of exhibit 1. So in view of the aforesaid discussion, I have the considered opinion that the order dated such and such part by the learned miss case number such is not sustainable as the decree was obtained without implementing appellant as party and accordingly it is set aside and consequently the execution proceeding become infructuous. So this is the finding, Lordship. The finding of the lower appellate court. Now the fact is that, Lordship, there was no such document, only on the notarized document that was exhibited. Lordship knows it very well that the marking of a document is not the proof of the contents of the document. You have to prove it. Since the objector filed an application to prove his claim, he has to prove with sufficient material on record that at that point of time, he was a tenant. And that is the reason why, Lordship, the learned lower court, the executing court came to a finding that there is not a single document to establish the fact that during the time of 2009, he was in possession of the property. And in absence of that, Lordship, the first aspect of the matter with regard to the substantial question of law, that the learned court below, the lower appellate court misinterpreted the evidence on documents. Misinterpretation why, Lordship? Because of the fact that there was not a single document to establish the fact during the relevant period of time, he was in possession of the property. What he was doing, he had produced certain documents which were of 2011, 2013. Now, if your Lordship kindly see the documents, which are probably a part of the record, these documents are all notarized documents. And the person who put the signature, even he was not called.
Documents of 2011 and 13.
13, Lordship. And the person who had executed this particular document as a landlord of the property, he was not called in the witness box to establish the fact that that period of time, during the year 1991 or after that 2009, when the suit was filed, whether he was in possession of the property or not. Because burden lies upon the person who claims certain facts. Because he was claiming that he was a tenant, just to establish the fact. Because my witness is not going to improve the case of the objector. This is the settled position of law, Lordship, because my witness may be there, but that cannot improve the case of the objector. He has to prove his own case. And there was not a single document to establish the fact that during the relevant period of time, he was a tenant in the suit premises. Now, what was his cross-examination, Lordship? I'm just referring to the cross-examination part.
So you first show me the documents.
I think it is there in the record, Lordship.
Show it.
Yes. The tenancy agreement, Lordship.
It was a notarized document.
Notarized document. Even that was not properly proved, Lordship. That document was merely marked as exhibit, but that has never been proved. Even the person who has executed that particular document, this Rajat Chatterjee, he was not issued any summon to appear before the court to examine the with regard to the
Rajat Chatterjee is the landlord.
Yes,
Yes.
he himself was the landlord.
Exactly,
How
Lordship.
he
Rajat
can be
Chatterjee
called as the other party?
Let me complete. Rajat Chatterjee himself was the landlord, Lordship, but during the period of time, he was suffering from mental illness. That's why his wife deposed before the learned court below. Deposed before the learned court below as a witness. Now the Rajat Chatterjee, when this Rajat Chatterjee had executed that particular document, he was not before the witness box because this is for the responsibility of the tenant. If I want to establish the fact that during the relevant period of time I was in possession of the property, it is my duty to call for the concerned witness to appear before the court and depose with regard to the correctness of the facts. But that was never been done, Lordship. And even that document, notarized document, so many corrections were there, Lordship, whether it has been done with regard to the knowledge of the concerned landlord, there is no explanation with regard to that. And that is the reason why, Lordship, when the learned trial court take note of this particular exhibit, made a specific mention with regard to the fact that not a single document was placed before the learned trial court with regard to the fact that during the relevant period of time, 2009, he was in possession of the property. There was a tenancy agreement of 2011. Subsequently, that was created and that was produced before the court. And that is the point we have raised in our objection also, when taking into account the mental.
What is the other document?
Yes, Lordship. The other document is the electricity bill. This is also of 2011. All the documents are of 2011.
Page number, those document?
The next one, Lordship. After the agreement, this is the electricity bill of 2011. Electricity bill, all documents, these are all.
This is passbook.
Yes, in the passbook.
Yes. Exhibit 3 is the passbook.
Passbook.
Exhibit 4 is a receipt.
Receipt.
Rent receipt.
Rent receipt.
Thereafter this electricity bill. It was
And
rendered
no
in
objection
the name
certificate of 2011, Lordship.
Or any Chatterjee, the plaintiff of the original.
Exactly, Lordship. And that is the stand we have taken in our objection also, that he was having some mental condition in our evidence. He was having mental condition in the relevant period of time.
So how this electricity bill will help you?
No, this is the 2011, Lordship. That is the thing I'm just referring to. Because these, whatever document that has been exhibited before the learned trial court, the executing court, these documents subsequent to the eviction decree was passed by the learned trial court. And that is the reason why, Lordship, the executing court came to a finding that not a single document was produced or exhibited by the objector with regard to the fact that during that period of time he was a tenant in the suit premises. So not a single document, whatever document he had exhibited, these are all documents after 2011. And these documents were procured by some other means, by Lordship. And that is the stand we have taken in our evidence also, Lordship, and in our objection also. And now, Lordship, kindly see the evidence part in the cross-examination of Tarachand Nahata. I'm just reading that, Lordship, and I'll give a flag mark to that. In the cross-examination of Tarachand Nahata, he has specifically admitted, Lordship.
You first mark the evidence because later on I will find it difficult to find it.
No, I'll put all markings, Lordship. Exhibit 1, 2, 3, 4, I'll put the markings. Okay. And even the cross-examination part also, Lordship. The cross-examination, I'm just reading that particular cross-examination, Lordship. In the cross, the objector had made a mention that I am resident of Shillong and carrying on business of government there from Shillong. I know the contents of my evidence in chief. I know the late Uma Chatterjee for last 25 years. I have Lordship Tarachand Nahata, the objector, the response number 1. I have my rented residence in the premises of late Uma Chatterjee on the 2nd floor. I have also taken on rent the ground floor consisting of 4 rooms. I have different agreements in regard to different premises. I have not exhibited, this is important, Lordship, I have not exhibited any document pertaining to tenancy agreement dated 1/4/1991, because what he was claiming that since 1991 he was in possession of the property, but not a single document was filed before the learned trial court with regard to the fact that he was in possession of the property during the relevant period of time. Case was registered against me in regard to possession of LPG cylinder. I have never kept any LPG cylinder in the suit premises, nor I used to keep it in the veranda. I am having, it is a fact that by playing fraud, the decree was obtained. I don't know how Anup Thakuria made a statement in written statement with regard his inability to pay rent. The contents of the written statement, I have made allegation of fraud against Anup Thakuria and decree holder. Since 1991 to 26/2011, I have not enlisted any tenancy agreement. So he has admitted in the cross that since 1991 to 10/6/2011, I have not enlisted any tenancy agreement. I have not exhibited any tenancy agreement. Before 2013, I have no tenancy agreement pertaining to suit premises. Because he is disputing his own agreement in that particular exhibited document lordship, in the exhibited agreement, he had made a mention that since 1991, this is a subsequently corrected lordship. If your lordship kindly peruse that particular exhibit 1, subsequently corrected, overwriting is there, and stating that since 1991 he was in possession. But in cross, he made a mention, specific and categorical statement. Before 2013, I have no tenancy agreement pertaining to suit premises. So this is the admission. Because if I am admitting in the cross-examination that I have no agreement with regard to suit premises, that means I was not in possession. In Exhibit 2, we have obtained the signature of Anup Thakuria, the judgment debtor, as a witness. Exhibit 5, it is not a fact. So that aspect of the matter is also relevant, lordship. The person who was a tenant, he put his signature as a witness in the Exhibit 1. The document which is the tenancy agreement. So it shows the collusion between the original tenant and the objector. Because the original tenant, when he failed to avoid the decree, the admission decree, then what he did, he inducted the objector into the suit premises just to create obstruction with regard to the execution of the decree. So Exhibit 4 is the rent receipt of November 2013 and December 2013. So all the documents which are exhibited, lordship, these are all after 2013, after the decree was obtained by the decree holder. And that is the reason why, lordship, the first substantial question of law which was formulated is with regard to the fact that the judgment, the impugned judgment and order was passed without proper appreciation of the evidence and the documents available on record. Now, the second substantial question of law is that, lordship, the section 101 of the Evidence Act. 101 is very specific, lordship, the burden. Burden of proof. Whoever deserts any court to give judgment as to any legal right or liability dependent on the existence of fact which he asserts must prove that those facts exist. So it is incumbent upon the objector to establish the fact that he was a tenant during the relevant period of time. And what he did, certain documents were marked, certain documents were exhibited to establish the fact he was a tenant during the relevant period of time. So there is absolute perversity on the part of the learned lower appellate court, lordship, by misinterpreting the evidence, by misinterpreting the documents which were exhibited before the concerned executing court. Now, lordship, in the evidence also he has admitted. Just now I refer to the cross-examination part. In the cross-examination part, he has categorically admitted the fact that he was, during that period of time, 2013, he has not exhibited any document to establish the fact that he was a tenant during the relevant period of time. So this statement is sufficient enough to establish the fact that he was never a tenant when the suit was filed. Because it is our case that initially he was there, but subsequently when he had vacated, because he has admitted that he is staying at Shillong. So that particular suit premises was not required during the relevant period of time. When he had handed over the possession of the property, that was given to Anup Thakuria. Now, Anup Thakuria admitted in the written statement that there is a default on his part in paying debt. And even he has admitted that he will make the payment in one shot, lordship. And that is the reason why the decree was there, the admission decree. Now, after obtaining the admission decree, he came to know, he had realized the fact that he has done some mistake. Now, when he realized the fact that was not in a position to overturn, so what to do? He had handed over the possession. This is the apparent on the face of the record, lordship, because the agreement which has been exhibited before the court, he was the witness. The tenant was the witness. So the tenant was not a stranger. So the Anup Thakuria.
He witness to the agreement between
the present objector and
Nahata and the
Chatterjee. So he cannot take a plea that I don't know this particular tenant. I was the tenant in the suit premises. And more to that, lordship, the learned lower court or the executing court, the opinion formed with regard to the fact that not a single document was exhibited. This is absolutely fact. And that aspect of the matter not taken into account by the lower appellate court while passing the impugned judgment and decree. In that regard, lordship, I want to rely on.
According to first appellate court, burden of proof is upon
the landlord, upon the respondent or the opposite party in the the order 21 rule 97 application. But the
application filed by the.
Respondent number one.
Yes, Nahata.
Nahata,
He has taken the stand that he was in possession of the
Possession.
sole property.
exactly, Lordship.
uh,
But while taking that
but,
particular stand, he could not produce a single document establishing that fact. Now the executing court dismisses the application. Lord Appellate Court went reverse. Lord Appellate
No,
Court came to a finding.
come to burden of proof.
Yes, Lordship.
So burden of proof lies upon whom?
Burden of
Dismiss
proof,
the court.
100, as per 101, it is upon the tenant to establish the fact. Yes.
Yes.
My lord, the facts remain that the possession was not disputed. When the decree was sought to be executed, I was in possession of supervisor. And this fact is not disputed, my lord. And my friend is saying now that there is no document to show. We could not, my lord, prove that we were in, my lord, admitted fact need not be proved. My lord, let us have a look at page 40, my lord, Majesty.
Page 40.
Page 40, my lord, para 5. Para 5, fifth line, my lord. 40, page 40, my lord, para 5.
Yes.
Fifth line, my lord. The fact remains that he is a tenant with respect to 1,200 square feet at the second floor of the same building. However, in the year 1991, he had taken the suit premises on rent from the predecessor of the decree holder by executing a deed of tenancy on 1/4/1991, and the same was in force for a period of 3 years, that is up to 31/3/1994. However, the tenancy continued till 2005, and as the room was kept unused without any purpose, he handed over the vacant possession of the suit premises in favor of the predecessor in interest of the decree holder in the month of March 2005. Thereafter, Sri Anup Thakuria took the suit premises on rent on 16/5/2008 by executing written deed of rent agreement and came into possession of the suit premises thereby. Now, my lord, my friend is saying that the respondent number one, he could not bring in the witness box, my lord, the landlord, my lord. My lord, landlord is the party himself, my lord. In fact, my lord, Mr. Thakuri was in fact in possession of the suit premises, my lord, and he has supported his case, ejectment suit, my lord. In the WS, he has totally supported his case that he could not make the payment of rent regularly due to his finance. My lord, what prevented him to bring Mr. Thakuria in the witness box to support that no, he was in possession of the suit premises, my lord? It was totally, my lord, a suit.
No. Mr. Gore,
My lord.
burden of proof lies upon whom? Who asserts the fact?
Yes. And my lord, I am asserting
So,
the fact that
you are asserting that you are in possession of the suit premises.
since
You are to
1991.
let evidence to establish the same.
My lord. No, my lord, I have my fact, my lord, that tenancy was in my favor from 1/4/1991. This fact has been admitted by the landlord, my lord. This fact has been admitted by the landlord, and subsequently, when I was sought to be evicted, I was in possession of this fact is also, my lord, on record, my lord. I was supposed to be evicted on the basis of decree passed against Mr. Anup Thakuria, my lord. So in the case of the appellant is that, my lord, in between Anup, there was some tenancy between the appellant and Anup Thakuria. So, my lord, this fact has to be proved by the appellant, my lord, because it is their allegation that I left the premises in the 2005, my lord, and they rented it, the premises to Anup Thakuria in the 2008, my lord. So from 2008, it remained in the possession of the Mr. Thakuria, my lord. So this fact they have to prove, my lord. When I am saying, my lord, that the tenancy was in my favor from 1/4/1991, and I remain in possession till I was sought to be evicted on the basis of a decree passed in against my lord Anup Thakuria. So this fact is, my lord, totally proved by admitted. This fact is admitted, my lord. So now, in between what happened, it is the burden lies on the appellant, my lord, to prove. And my lord, Anup Thakuria was very much in their favor, my lord. They could have easily, my lord, brought in him to him in the witness book. He could have said, yes, I was in possession.
No, first you have to establish, you have to discharge your burden, no?
I have no.
It may shift to him. necessary.
my lord, this fact is admitted by the appellant, my lord. My tendency in my favor from 1/4/99 is admitted, my lord. And my lord, when the decree was sought to be executed against me, this fact is also on record, my lord. Otherwise, suppose, my lord, when it was, when the bailiff came to my premises to evict me, my lord, suppose, my lord, I was not there. If Anup Thakuria was there, my lord, he could have easily, my lord, handed over the possession. I may not have been in a position to, my lord, resist the decree, my lord. There was no necessity of resisting, my lord. Suppose I was not in a possession, then I could not have been aware of the, my lord, the execution of the decree. It was only because, my lord, this Anup Thakuria, my lord, the tenancy agreement and the suit with Anup Thakuria, these all are, my lord, fraudulent transaction between the appellant and Anup Thakuria. And that is the reason, my lord, the appellant has never brought the said Anup Thakuria in the witness box. And even in this appeal also, the second appeal also, my friend has, my lord, prayed that the name of Anup Thakuria and his own sister, my lord, may be removed from the deleted, my lord. And the order is of this honorable that it is the name of the response 2 and 3 have been deleted at the risk of the appellant.
These are all question of fact, Lord.
No,
Substantial question of
no
law.
fact, my lord. Admitted fact need not be proved, my lord.
There are nothing.
I was in possession, my lord. That was the point I raised the objection, my lord. Otherwise, I have no reason. My lord, suppose I am residing in Ceylon and the decree is being executed at Guwahati, my lord. How, my lord, I can come and resist the decree, my lord? And tendency will be.
Merely because you have resisted execution of decree, that does not mean that you are in possession of the suit.
No. They have not denied, my lord. They have not denied my possession, my lord. At the time of execution of the decree, they have not denied my possession.
How can I deny, Lordship?
No, how
He
why
was
not, my
objecting,
lord?
he filed the
Why-
case.
No, why not, my lord? I have adduced my evidence, my lord. What prevented them to adduce their own evidence, my lord? They could at least, my lord, they could have adduced the evidence of Mr. Anup Thakuria.
Okay.
My lord, it is a totally fraudulent case, my lord. A decree was opened in the name of somebody else, my lord, and eviction was, and somebody else is sought to be evicted, my lord. It's a totally.
Then why these documents are procured only after
No,
passing of the
my lord,
decree?
suppose, my lord, if we assuming that this, no, not fraudulently procured, my lord, it is there.
No, we are not saying fraudulently.
My lord, suppose, my lord, I was not in a possession of the year 2011 or 2013, then, my lord, why he has issued rent receipt to me, my lord? Why has he issued rent? It is the very person, my lord. Why, if I am not in a possession, why he has received rent from me, my lord? Suppose I am not in a possession, then why rent receipt is to be issued to me,
Rent
my lord?
receipts are exhibited here.
Yes, my lord.
That are all defined here, Lordship.
Admittedly, my
Not with regard to the relevant here.
2013, just
Subsequent to that, these are all
trial code, my lord,
manufactured documents, subsequent to the
trial
decree
code.
that was obtained, Lordship.
No,
And
why?
even today also,
Even,
Lordship,
my lord,
if he is a tenant, I am not admitting that aspect, but even though if the court, if he is saying that he is a tenant, how he is paying the rent? He is not paying the rent.
my lord paid 49.
If he is saying that I am a tenant since 1991, he is not paying the rent.
Well, yes, you are at liberty to
No, that's a
file
separate
suit.
issue.
You
That's
are
a
at
separate
liberty to
issue.
file a separate suit for
Separate
eviction.
issue.
My lord, page 49. my
He was
lord,
never a tenant.
read it, my lord. Second paragraph. My lord, during the cross-examination of PW1, he deposed that he has taken the ground floor and the second floor on rent from the predecessor of the decree holder, late Uma Chatterjee, via different agreement. PW1 admitted that as regards the tenancy of 1/4/1991 to 10/6 to 2011, he has not submitted any tenancy agreement.
Not a single document, Lordship.
No, tenancy, my lord, 1/4/1991 agreement they have admitted, my lord. So the admitted fact need not be proved, my lord. So there may not be, my lord, any further agreement, my lord. Further deposed that before 2013, petitioner has no tenancy agreement with the landlord. May not be, my lord. My 1991 agreement is going on, my lord. So there may not be any subsequent agreement, my lord. it's not necessary that we have to keep continue, my lord, renewing the agreement, my lord.
No, agreement otherwise not required, but where is the
Exhibit, my
tenancy,
lord.
this
Exhibit
rent
4
receipt.
my lord, Exhibit 4 is the rent paying receipt of November and December 2013. My lord, if I was not in a possession, why, my lord, he issued the rent of rent receipt for November and December 2013, my lord? If I am not there, my lord, why he will receive rent and issue rent receipt to me, my lord?
Has been issued or not, there
Yes.
is no certainty with regard to that. How does
No, it
these
is-
documents have been
No,
proved? This is our point in
it
the
is the
substantial
evidence-
question
it
of
is the-
law.
It is the evidence.
Mere exhibiting a document is not to be construed as a proof of the documents. Proof is required, lordship. These documents are being exhibited only. Mere exhibits.
No, mere exhibit means.
There's a judgment of the Honorable Apex Court. Mere exhibit of a document is not the proof of the contents of the document. Certain documents are being exhibited. Can it be construed as the proof of the
Then the law
document?
is also that, my lord, the admitted facts are not, need not be
There is
proved.
no admission,
So
because you have denied the
if
fact.
my
you are
tenancy is
denied.
admitted from 1/4/1991, then in
We are
between
not on
what happened, it is the burden lies on him, my lord.
We are not on 91.
This fact is admitted that the tenancy was with me in from 1/4/1991. And
Who has put the
the
signature?
allegation of my friend is that, my lord, from 2008 to 2011, there Mr. Thakuria was in possession. So the burden lies on him to prove, my lord, that Mr. Thakuria has entered in the tenancy in between, my lord. My case is very clear. Since 1991, I am as a tenant, I am in possession of the suit premises, my lord. Now it is his case that from 2008 to 2011, Mr. Thakuria was, my lord, as a tenant in my place, my lord. So the burden lies on him to prove, my lord, this fact. How I can, when the premises in my possession, how I can know, my lord, that my landlord has entered into agreement with somebody else, my lord. And without bringing that person in the witness box, what prevented him, my lord, to bring Thakuria as a witness, my lord? If he was really in possession of the suit premises, he could have easily, my lord, because he has supported the case of the, my lord, the fraud played between the by the plaintiff and the defendant in the title suit is apparent on perusal of the written statement itself, my lord. Otherwise, my lord, how a tenant can admit that yes, he failed to pay the rent, my lord? In a ejectment, you also know very well, my lord. In a ejectment suit, that the tenant will admit that yes, I could not make the.
Maybe.
No, then, my lord, why he will object? My lord, why he will not hand over the possession, my lord? If he has to admit, then he has to hand over the possession also, my lord. Totally, my lord, contradictory. How totally improbable, my lord. How a man of my lord, the common man of general prudence will admit and he will not hand over the possession also, my lord. A fraud has been played, my lord. And that is the reason, my lord. This, my lord, my friend is, my lord, suppose, my lord, I am not making the payment of rent. This, my lord, this proceeding started way back in the 2015.
In this proceeding, we cannot decide that issue.
Exactly, lord. We are on a different issue.
No, that is true, my lord.
And we are not admitting him as a tenant.
But, my lord,
We are not admitting him as a tenant. He is an encroacher.
My lord, but the lordship has to also decide, my lord, the substantial question has to be framed, whether the decree was obtained by fraud or not.
No, a substantial question of law has already been framed.
No, framed, but where is the perversity, my lord? Where is the perversity?
This is the perversity.
Where is the perversity, my lord? There is no
When he has admitted in the evidence, lordship, that there is no document he has annexed.
No, document may not be, my lord.
And mere exhibiting a document is not the proof of the contents.
Oral evidence also, my lord. Not in all the cases.
In oral evidence he has admitted. In oral evidence
he has admitted that I was a tenant, my lord.
Okay. Let us do one thing. We will fix it tomorrow. You produce the judgments.
Yes, lordship.
The judgments.
My lord, then, my lord, can it be on next? I could not.
Only for judgment.
I could not.
Only for production of judgment with some relevant.
My lord, I did not go through the tenancy agreement, my lord, because in the trial court, there was somebody else was there. my lord. I only have the memo of appeal, my lord. So I could not go through the evidence and if can provide me a copy or I can be allowed to obtain from a copy of this, my lord, the agreement and the evidence. only.
You have the copy with you.
My friend has.
No, I can give him right now.
What is some copy
Yes.
to him?
My lord, evidence of my lord, this Tarasan Nata and my lord, the agreement, tenancy agreement. Only.
No, he can take the copy, lordship.
Yes.
Tomorrow he can hand over
Yes,
this
yes.
copy to me.
That tomorrow.
Tomorrow. Tomorrow at 2, lordship, if it is possible. At 2, if it is possible.
2.
At 2, lordship.
Okay.
In the record, 52 has been followed, lordship.
Follow. Can you show it?
Lordship.
Yeah, this here. Bill method to Julian, Reuters Rosida. Reuters, 28, Reuters. Item 28, Julius.
My lord, can it be on Thursday, my lord? Tomorrow is not, I have to go through.
No, I don't have any problem.
Thursday, my lord, because my lord, I am only having the copy of memo of appeal. now.
Thursday 2, lordship.
At
Any,